stop sharing. A very good morning to everybody. Please bear with us. We would be starting shortly. Good morning, everybody. We will be starting shortly. Please bear with us.
Hello. Ms. Sonali, I am Dr. Amrish Kumar. Am I audible to you?
Yeah, welcome, sir.
Am I audible to you?
Yes, sir, very much.
Thank you.
A very good morning to you. Education is the passport to the future. Tomorrow belongs to those who right today. A very good morning to all and warm greeting, Ms. Sonali and I, and Professor. On behalf the College of Law, the Department and Physical Education, the Internal Quality Assurance Cell, and the associate Kare College, I cordially welcome you to the national webinar on sports. The Vidya Vikas Mandal is a premier society founded 4 decades ago by dedicated and committed visionaries. This endeavor resulted in the establishment of many educational institutions from KG to PG, even beyond, which today have grown by leaps and bounds. Govind Ramnath Kare College of Law is the second child of the Vidya Vikas Mandal to be a center of excellence, providing quality legal education with a spirit of developing professionalism with social commitment. And it fills my heart with pride to mention that our institution secured NAC accreditation with B++ at a CGPA at 2.78 on a 4-point scale. This legacy and commitment of the Vidya Vikas Mandal and the vision of its institution is nurtured and carried forward by the able incumbent Board of Management under the committed leadership of heads of institutions. Ladies and gentlemen, I am pleased and it is my proud privilege to acknowledge and deeply appreciate the presence of the Vidya Vikas Mandal and the chairperson of the governing council of G.R. Kare College of Sri Nitin Kunkolekar, of the institution, Dr. Saba De Silva, Chair Alumni Association and member of the governing council, Advocate Prasad. We are also deeply honored to recognize and have in our virtual presence a galaxy of Dr. Lovely Das Gupta, Associate Professor, West Bengal National University of Juridical Sciences, Professor Dr. Ambarish Kumar, Advocate Supreme Court, Sports Attorney, Mr. B. Vivek Anand Sagar, Consultant and Attorney, Patent Information Center, Karnataka State Council for Science and Technology, Bangalore, Professor Dr. Professor, National Law School, India University, Bangalore, and Advocate Partner for Commercial Bangalore. I also urge the presence of the IQAC coordinator, Assistant Professor Dr. Gaurathi Moy, and the Physical Education and Sports and Program Manoj, as also esteemed colleagues, all the and YouTube channel. The history of any institution is carved by guardians, keepers, its brain limbs, who agree to slave for nothing but the best. Dr. Saba De Silva is head of the institution, and it would be befitting the occasion to have him deliver a formal welcome address. Dr. Saba De Silva was born in 1968 in Margao, Goa. He pursued elementary education and completed his ICSE from Mount Abu, Rajasthan in India. Thereafter, he completed SE in chemistry from Srimati Parvatibai Chokle College, Margao, and medical biochemistry from Goa Medical College, Pampli, Goa. He has secured a gold medal for ranking first at the MSc examination of Goa University. He was appointed as a research assistant in the Department of Biochemistry, Goa Medical College, in a funded research project where he published his article in Neuroscience Letters, an international journal from the Netherlands. He has served as part-time lecturer in biochemistry in BSc program at St. Xavier's College, Mapsa, Goa, and has also taught physics and chemistry in few schools at high secondary level. He was selected by the Goa Public Service Commission and has served as Chief Biochemist of Directorate of Services, Government of Goa, for about 8 years. He completed LLB degree through this institution, the Vidya Vikas Mandal's Govind Ramnath Kare College of Law, and LLM degree through VM Salgaonkar College of Law, Miramar. He has secured gold medals at both these examinations of Goa University. He has a rich teaching experience of over 20 years since 2001 at this institution, of which he is an alumnus. He completed PhD degree from Goa University in the year 2011 and drafted a model law for biomedical waste management for the state of Goa. He is a resource person at seminars, talks, workshops, conferences all over India and abroad. He has been a resource person and has delivered lectures at the University of Lisbon and University of Minho in Portugal and the University of Fortaleza in Brazil, and is credited with entering into MOUs with many foreign universities. He has been appointed principal of this institution in April 2017. I beg your pardon. He has also served as a member of Unfair Means Inquiry Committee, Committee on Patents and Consultancy, and Committee on Drafting and Vetting of Statutes and Ordinances, all for the Goa University. He also is a member of several other committees of the Goa University. He has been appointed as Dean of the Faculty of Law, Goa University, in the month of March 2020, and is also the chairman of Board of Studies in Law of Goa University from May 2021. He has been a research guide to LLM students of Goa University for past several years and has commenced the research center at the Vidya Vikas Mandal's Govind Ramnath Kare College of Law, affiliated to the Goa University, and as a PhD guide for research scholars in law at the center. He also has several publications to his credit, both in pure sciences as also in social legal sciences at state, national, and international level. I welcome you, sir, and request you to deliver the welcome address.
Thank you very much, Assistant Professor Sonali Naik. Can you just confirm that I am audible?
Yes, sir.
I'm audible.
Yes, sir, you are.
So it is, I'm delighted actually to welcome all of you for this national webinar on sports law. We are actually very, very happy that finally we have made that connect between sports and law, and we can readily address these needs, these concerns which connect the two subjects and which are so much relevant in today's world. I'm particularly very happy that we have with us Dr. Lovely Das Gupta, that is the Associate Professor of the West Bengal National Law School. We have Professor Dr. Amresh Kumar, who is an advocate of the Supreme Court and a sports attorney, and of course other resource persons like Mr. B. Vivekanand Sagar, who is consultant and attorney of the Patent Information Center in Karnataka, and Professor Dr. Sairam Bhatt, our very own old faculty, ex-faculty, is one of the shining stars that was with us, and Advocate Rohit Kumar, who is partner of the Corporate and Commercial Practice Rex Law Chambers. And I also am delighted that we have with us the president of Vidya Vikas Mandal, Mr. Nitin Kunkolekar, who is a national figure and needs no introduction, basically. I thank at the very outset Mr. Manoj Hede, who is the college director of sports and who is coordinating today's program. And of course, this is an IQAC initiative also, so we need to recognize the efforts of Dr. Goretti Simoins in putting this program together. We have others who will be also with us and who will be duly acknowledged in the course of the program and towards the end. I need to say a little bit about our college because this is a national program, and it is befitting that we need to recognize that Kare College of Law is 4 decades young, and it was actually commenced because we needed to fulfill the aspirations of the students from the south of Goa. Goa is very small, but it's not so well connected. And so there were students who would have to go to the north, which was a college started about 6 years prior to the Kare College of Law. So initially, this was all part of Bombay University, and with the commencement of Goa University, we have the only state university. We have Kare College as affiliated to it. We also are recognized by the Bar Council for imparting professional education. And of course, we have the 2F and 12B UGC status. As mentioned by our able compeer, she has discussed about the very impressive grade for NAC that we are just entering into. We have 5 years to live with this grade. Kare College offers, basically it offers 3 programs in-house. We have the undergraduate 5-year and the 3-year law program, and we have the master's program in law. But in addition, we have this research center, and we have PhD scholars who are pursuing doctoral studies. Now, this college also offers a repertoire of certificate courses. Notably, we have a very prized Indo-European Comparative Studies program, which is part of the MOU initiative we had with Lisbon University, and one of its kind Portuguese language course with legal inputs, perhaps the only one in India. It has therefore been providing these certificate courses to the students, and we also facilitate the undertaking of several diploma and certificate programs through IGNO Law Study Center, which is predominantly catered to by the college professors who are academic councils. Now we have a very good infrastructure. Unfortunately, this is COVID times. Otherwise, you would have been with us to be part of that lovely ambience we have at college. We have a well-equipped library, and we have a disabled friendly multi-storied building with an elevator facility. And this institution prides itself with certain best practices and institutional distinctiveness by taking legal assistance to a whole new level by creating 21 legal assistance clinics in majority of the talukas of the state. Now, the students are therefore given live experiences in providing legal aid to the needy through all such outreach co-curricular activities, and they are churned out into society as holistic individuals, for which their placement is facilitated by this institution with campus interviews that are conducted periodically. Now, these noteworthy characteristics, including another very critical one, we have started the Permanent Legal Counseling and Facilitation Center for Senior Citizens. So with all this, we have won national accolades. The college has collaborated through over 20 memorandum of understandings, both at national and international level. The most recent one was with the prestigious 13th century UNESCO Heritage University of Coimbra in Portugal, when the president of Portugal visited Goa the last year. In fact, our college has a unique research protocol with Mozambique and of course Brazil and Portugal. So this is giving Kare College of Law a global presence. Now, in our quest for excellence in the field of legal education, we are taking these giant strides, and we are striving to be the best in the field of legal education in India, for which we have a tremendous support of the Board of Management led by Mr. Nitin Kunkolikar, who's here with us today. Now, for this commitment, we also have a dynamic team of well-qualified faculty and staff that deserves due credit. Now, if you look back at the glory that we have, the institution academicians that we have created, we have well-praised corporate employees, high-ranking officials in the bureaucracy, the former advocate generals of the state. 3 of them were from our college. One former, we had the, not former, as in one of the lady judges of the High Court has retired, but we have the other woman judge, the only women judges from Goa in the Bombay High Court. Of time, I'm sorry about that. I once again welcome each and everyone present here, And I once again hope that these deliberations in the field of sports and law will take us a long way. Thank you very much for your patient hearing, and I hand over the mic again to our compeer, Ms. Sonali Naik. Thank you.
Thank you, sir, for those warm and hospitable words. I now declare this webinar open. Let us feel a field of energy around us and stay tuned to welcome the enlightenment this exercise of knowledge will bestow upon us. A proactive support of the management paves the way for the growth and the progress of any institution. The Vidya Vikas Mandal, as also our institution, is fortunate to have a stalwart and robust backing of a dynamic personality, respected sir, Sri Nitin Kumkolekar. Sri Nitin Kumkolekar is the president of the Vidya Vikas. He also has held and holds numerous influential positions at state and national levels. He is the president of the main Manufacturers Association for Information Technology, India's top business association committed to the mission Digital India of the Honorable Prime Minister. He is also the chairperson of Vibrant Goa Foundation. He is a member of the Confederation of Indian Industries, National Council 2020-21. He is also the member of the Governing Council and board member of Electronic Sector Skill Development Council of India. He is a member of the Higher Education Council headed by the Honorable Chief Minister, Government of Goa. He is also the member of the Governing Council of National Productivity Council, New Delhi, headed by Shri Piyush Goyal, Union Minister. He has served as president of the Goa Chamber of Commerce and Industries for 8 long years. He is a panelist and speaker at various forums, summits, events organized by the government as well as non-governmental bodies, and has participated in discussions on union budget related consultation process. He is also a recipient of several awards. May I invite respected Sir Sri Nitin Kumkolekar to address the forum. Kindly take over.
Good morning. Yeah. Good morning. Thanks, Sonali, for the lovely introduction. Though it was not needed to be so long, it should be very short because we are here to listen to very eminent personalities who are experts in their field. So at the first outset, let me congratulate GR Kare College of Law for finally organizing this event, because last 6 months due to the challenging times we had to postpone. And thanks to Saba also, today he has made a very important statement which is very reassuring. He says that finally sports and law have come together. That's very reassuring. That's very important for us as well. My deepest gratitude to distinguished speakers, Dr. Lovely Dasgupta, who is going to speak on gender discrimination, Mr. Vivek Anand Sagar, who is going to talk about IPR and sports, and Mr. Dr. Sairam Bhatt and Advocate Rohit Kamath, and the guest speaker, Professor Dr. Amresh Kumar, for agreeing to be the speakers of this event. I must also congratulate Dr. Saba and our Assistant Professor Manoj Hede for working very hard to ensure that this event takes place. To be very honest, I wasn't aware that sports and law has something to talk about. But as we were getting ready for this event, a lot of topics were emerging, and I said it's one of the most important aspects today. The world is changing today, world is getting converged, the world is getting converged with many other topics, different topics are getting converged, technology is getting penetrated, and I think all of us in future will have to deal with it in a very strong way. It's time that academic institutions like us and many other across the country, including the national law schools, should come forward and try enabling an environment to bring sports and legal side together. Today, sports also is emerging as one of the biggest economic activity. If you see the value chain of sports is one of the outstanding value chains, and it has created a very high multiplier effect. And the best part of development of sports today in this country is it has reached the rural mass of this country. Of course, the legal aspects are still being deliberated at most urban-centric areas, but the sports as a profession has started benefiting the rural mass, and most of the states have started concentrating on the rural areas to find the talent to develop them. And I think if you look at this particular profession very broadly, in 5 to 10 years time, India is going to be one of the larger players in sports. After Make in India, Design in India, Develop in India, I think it's also going to be youth affairs and sports are also going to be one of the major activity. Look at China. China just didn't develop the manufacturing sector or a development sector or service sector. China started also developing their sports, and today in every aspect of sports, China is doing very, very well. Same thing is the case with most of the developed nations. While they develop their economy, they also develop their sports economy. And I think as this aspect is going to grow, the legal aspects of sports are going to come up in a bigger way. And that value chain will extend to the legal profession in a big way. And I think the law colleges and the national law schools and the universities should take a larger role in understanding the future of this particular topic. I'm really delighted that our college decided to host this event. My welcome to all the panelists, speakers, all the participants across the country. It's really nice of them to be part of this event at such a critical time where most of the people are going through webinar fatigue. I mean, people are also tired of webinars and still they decided to participate. That's something very nice. The pandemic has thrown a lot of challenges on us, but yes, very soon we will come out of it. I'm very confident of that. I would like to have more such events organized in Goa, and I'm sure no one would say no to this. Today, I have to welcome you and receive you all virtually. But very soon, maybe after 6 months or so, we can look forward to another event which we can host, I mean, in a physical presence or maybe in a hybrid mode. And it will be real pleasure to have you all interacting on a one-to-one basis. We would like to be a platform at GR Kare College of Law. Every year, our priority is to raise the bar. We want to raise the standard of legal profession here. We are taking a lot of steps. 2.78 may not be a big achievement as far as NAC is concerned, but we have to understand this ranking is in terms of the new stringent norms created by NAC. So if you compare on apple-to-apple basis as compared to the previous ratings, definitely we have done 3+. And that's where I really congratulate my team for taking our college to higher standards. But it's our endeavor to become one of the best center of excellence in legal profession. And in this regard, I also would seek help from experts like today's speakers and others. Dr. Sairam Bhatt, who is our past faculty. If you could help us in shaping up the future of this college, I'll be really grateful. I wish this event all the best, and the deliberation would be of immense benefit to all of us. Besides looking at the legal aspects of it, I also would like to take some good points which can talk about expansion of sports as a business, sports value chain, economy, and convergence of all these topics. Thank you. Wish you all the best. Have a lovely Saturday. Thank you.
Thank you, sir, for your gracious presence and your valuable time. We appreciate you for the support and encouragement you extend to this institution and to all our activities. Thank you. We now move on to business. Sports are about those incredible moments where sheer human will and desire overcomes the order. These moments make history, and these moments live forever. Although sports originally belonged to the genre of entertainment and leisure, it has over the decades shaped into an industry. It is a market with economic dimensions which offers products, services, fitness, and leisure to its consumers and involves not only sportspersons but also others who facilitate, promote, and organize sports. Sports laws touch a variety of issues: contractual, commercial, tortious, constitutional, labor, human rights, IPR, etc. Sports laws assure safety, equality, fairness, integrity in athletic competitions on and off the playing field. Today's webinar on sports laws will focus on some related topics. Focus, determination, pain, disappointment, excitement, suspense, anger, relief is all part of the game. Whether you are a man or a woman, any work, former lacrosse player. However, the road to equality has been far from easy for a woman sportsman. The first resource person, Dr. Lovely Dasgupta, will address the issue of gender discrimination in sports. May I call upon respected Sir Advocate Prasad Naik to introduce this lovely lady to our audience. Advocate Prasad Naik is the chairman of the Alumni Association of GRKCL. He is also a member of the governing council, and I'm pleased to mention that he is also the alumnus of this institution. Over to you, Sir, Advocate Prasad Naik.
Good morning, everyone. Am I audible, Sonali?
Yes, very much, sir.
Yeah, okay. Good morning, everyone. As president of GR Kare College of Law Alumni Association, it is our pleasure to associate with our alma mater and jointly host this webinar on sports law. In the past, we have also hosted various national level events. It is my pleasure to introduce our resource person of today's webinar, Dr. Lovely Dasgupta, who is an expert in the field of sports law. Dr. Lovely Dasgupta is currently working as an associate professor law in the West Bengal National University of Juridical Sciences. She has done her master's and MPhil in sports law. Her book in World Anti-Doping Code, published by Routledge UK 2019, is one of the leading books on the issue. Her current work on non-Olympic sports is under publication with Routledge USA. Further, her co-edited book on sports policy in India has been published by SAGE in 2018. She has been teaching and researching and writing in the field of sports law for the past 17 years. Apart from sports law, Dr. Dasgupta has got research and teaching experience in the field of competition law, commercial law, contract law, consumer law, and legal education. I am sure that her expertise in the field of sports law and her presentation would enrich us on the topic, gender discrimination in sports. It is my pleasure to present before you Dr. Lovely Dasgupta. Over to you, Sonali.
Thank you, sir, for doing the honors. May I now request Madam to take over the forum.
Thank you so much, Sonali. Thank you, Prasad Naik. Thank you so much, Advocate Prasad Naik, for the generous, introduction that you conferred. And I'm really honored, and it's a pleasure. It would have been more pleasurable if it could have been in Goa itself, but unfortunately, the terms and the situation doesn't help us much. So as per the schedule, I've been allotted 30 minutes, but considering that it's 10:35, I will try to wind it up by 10:50 as given in the schedule. Because see, I tell you what, whatever we may feel about, webinar fatigue is a reality, right? And everybody is switched off and we don't know whether they're even attending or not. That's what happens in classroom also, believe me. Students just switch off. They're logged in, but they're not to be seen. And that kind of, we don't know whom are we speaking to. It's nice, at least I can see Professor Dr. Amresh Kumar. Thank you so much, sir, keeping on the video on. Sonali's beautiful face is visible. And thank you, Advocate Prasad, for keeping the video on. Okay, so yeah, so without, hello, sir, namaskar. I'm really honored that you also have switched on the video. So without much ado, this is a topic which has affected India, that is the gender discrimination in sports. But it's also an oxymoronic title, primarily because sport is gendered. You talk about women's cricket, you talk about cricket. Recently, to be politically correct, we started saying men's cricket and women's cricket. But believe me, when we are watching cricket, it's cricket versus women's cricket. Okay, so it is never men versus women, right? Same is the case with hockey. Take football. India hardly has much to do with football at the moment, current, as we are concerned. Anyway, the point now, yeah, right. Thank you, sir. Thank you so much. Yes, I understand. Bandwidth is issue, When I ask my students, why are you not logged in, they say bandwidth issues. This is a common thing we are very used to. Anyway, so coming back to the point, so when you talk about gender discrimination in sports, so it is inherent. And unfortunately, whether we like it or not, the International Olympic Committee, all the international federations have internalized it through their rules and regulations, given biological justification. Recently we talks about mixed tennis taking place, but it hasn't taken off at all. We continue to have men's and we have women's. Now, the reason why gender discrimination has become a trending topic as we are speaking is because there is more to the binary than we are comfortable with. So apart from men and women, we are also talking about other gender designations. So as we are all aware that Miss Flubber became one of the first athlete to qualify in the Tokyo Olympics as a transgender athlete, and she's going to participate in the women category. But the problem with sports is they haven't gone beyond these two genders, male and female, right? So apart from the discrimination that we get to see in the reality, in the ground level, vis-a-vis the competition structure, vis-a-vis the prize money, which is recently being made equal, vis-a-vis the exposure level, vis-a-vis the marketing rights, more so in developing countries, right? And there are n number of literature. If you do a Google search, you will find n number of literature written in sociology, in various other streams like science, apart from, of course, law, which talks about the inherent, biases against women participation in sports. So women participation in sports is definitely an issue, but the additional issue that has come up to the fore is the transgender or the other gender issue. Hence, the question is, how do we accommodate these various claims, these various settings? Do we have a single event for both the genders? Do we go for a single competition instead of men's 100 meter and women 100 meter? Now, the other end of the argument is that biologically men and women are different. So if you bring them together in a single competition, that wouldn't be fair for the participants, be it women, be it men, right? So therefore, it is justified on the ground that biologically men and women are different. Hence, we need to have different competition. For example, you need to have a separate event for men 100 meter because men run faster than women in terms of, that is evident from the records that have been set in this field. So the justification given by all the sports governing bodies, is this, that we need to have separate competitions because men and women are biologically different. Now, this comfortable argument gets disrupted when you come across an athlete like Caster Semenya, who is participating in female category but supposedly runs faster than average female. Interestingly, you don't get to see these kind of arguments being given vis-a-vis Usain Bolt's record. Why? Because Usain Bolt is genetically structured in a manner that he will have a physical advantage vis-a-vis other participants in that competition. But when it comes to Caster Semenya, you point out that, look, she looks like a male. Why? Because she has a higher testosterone level in her system. And that is something which was treated problematic by the International Athletic Federation. So they came up with what we call the rules pertaining to dysfunctional sex formation, the androgynous, the hyperandrogynous gynism that we call. In other words, females are supposed to have lower level of testosterone. But if an athlete, a female athlete, has a real high level of testosterone, then even though she is born a female, she has to undergo certain treatments to be equal or equated with other female participants. Right. So you have athletes like Paula Radcliffe who have supported this position. Why? Because they say this gives an unfair advantage to athletes like Caster Semenya when they are competing with the other female participants in the sports. Now, why is that problematic? That is problematic because it is not artificially induced testosterone level. It is inborn. Look at the case in India. We got to know about it. We did have an issue earlier, but we got to know about it in a more progressive way when Duti Chand won the case in 2015 before the Court of Arbitration for Sports. But please understand, when you go through the Duti Chand decision given by CAS in 2015, CAS didn't say that IF is not supposed to do these kind of discriminatory practices. No. CAS said there is no scientific evidence adequate enough to justify IF's rule pertaining to treatment of this situation in females. That's the reason, on the basis of ambiguity, lack of clarity, they suspended the rules for 2 years. That is the reason why Duti Chand was very relieved in a way. Subsequently, after a lot of criticism, when I did come up with its rule on gender discrimination, on hypoandrogenism and testosterone level, it excluded 100 meter and 200 meter. It does not apply to 400 meter and 800 meter. That is the reason why you cannot allow Caster Semenya to participate in the case. She has to undergo, mandatorily, she has to undergo a medical intervention to correct, as the IF says, her situation. Now, these kind of arguments, unfortunately, are not given in the case of male athletes. They are not, look at Muttaya Mullidharan. He had an arm defect genetically, but you never questioned it. If anyone wants to question it, they will say, okay, it's natural. Okay, look at Michael Phelps. Look at N number of athletes. I can go on with it. But the moment it comes to a woman who doesn't appear to be a woman, who doesn't look like a woman, you start questioning. And there is a problem. The problem is the stance of these federations, which they have changed over the years. Earlier, they used to categorize it whenever they used to think, whenever they used to talk about female and male, as I said, they used to categorize it based on gender. Born male, born female. That is gender. Now they are categorizing based on sex. Sex and gender are different. If you read biology, if you read sociology, sex is based on your chromosomes inside, XX, XY. So if you have greater amount of testosterone, you are predominantly having XY, which overshadows XX. Now this is problematic as well. Why do you change the parameters in case of women? Duti Chand argued that she was born a female, even though she looks. Look at our case. We have N number, as I said. We had Pinky Pramanik, but her case, for whatever reason, didn't catch. It only caught attention of media when the police case was filed. But prior to that, how many of us really did debate on such issues? So when you're talking about gender discrimination, please understand, first thing first, the argument of discrimination is neither entertained nor is a legitimate argument within the parameters of sports as far as the international federations or the national federations are concerned in terms of separate competition. Separate competition is given. It is given since the ancient times. It is given as a reality. You will never have Mithali Raj and Virat Kohli playing in the same team. Okay, so we will never have single competition. As I said, interestingly, the justification is gender, biology, separate, different. Okay, so you are celebrating the difference as the argument. But the question of discrimination definitely comes in when we talk about transgender, when we talk about third gender, when we talk about people who do not fit in within those binaries. Then the question of discrimination comes in. Unfortunately, none of the federations have yet accommodated that. Now, why do you think it took so many years for a transgender athlete to qualify in an Olympics? Because of the lack of space, because of the lack of accommodation. And they are, believe me as I say this, they are not going to change it. Maybe over the years from human rights pressure, but that will not work. What will work, of course, as Sir was saying, as Dr. Sabha was saying, from the pressure of the commercial people who brand Olympics, who brand athletics, who brand cricket. From them, yes, if you have to show that you are for gender neutrality, maybe they will give the choice to the transgenders to select which gender they would like to participate in. Would they like to participate as female or as male? Okay, so this is the point which you need to keep in mind, because as Sir was saying, please remember, when we are discussing today's sports law, we are primarily discussing because of the reason that a lot of commerce is involved. It is no longer about, if you've seen I don't know whether you've gone through the write-ups on New Zealand's win in the World Test Championship, becoming the champions, right? The reason is New Zealand shifted from amateurism to professionalism as cricket is concerned. And that was celebrated. That is being celebrated. So the point is, sports is a matter of livelihood for a large number of people. Hence, the questions of human rights, hence the questions of discrimination are an important reality for us. So and not for us who are speaking, but definitely for the people who are practicing it. So if you bar a Duti Chand or a Semenya, now we had a classic example of Santi Saundara Rajan. She ended up being cold. She tried to commit suicide because she looked different. She didn't look like a woman. She wasn't allowed. She wasn't accommodated. She tried to commit suicide. Times of India reported her case. Then she got a coaching job. So this is the reality we're living in. Okay? So unless the systems change, unless there is a clear-cut argument that if you're naturally born different, so be it. There shouldn't be any decision based on objectification of what a woman should look like, what her sex ratio should be. We continue to have these discrimination amongst us, these regulatory gaps amongst us. Okay? So thank you very much. I have completed 1 minute is still left. I have just pointed out the issues. So I think I will wind up. If you have any questions, please feel free to ask.
The question and answer session is open. Audience, do you have any questions? Any questions from the audience? Okay, there is a suggestion. There is a suggestion come from Dr. Amaresh Kumar. Let the question hour session be at the concluding session. That is what is his request. If there are no questions, let me proceed.
Okay, thank you very much.
Thank you, Dr. Das Gupta. It was a very impressive presentation. And I appreciate you for giving us insight into the various women's issues, as also issues relating to transgender and third gender that fuel discrimination and negate the human rights of sportspersons. Thank you very much. Commercialization of sports has resulted in big-time monetary gains to various sports and sports-related stakeholders. Today, IPR are used as marketing tools towards branding of games and related events, all of which require protection against acts of infringement and unauthorized use of trademarks, copyrights, designs, and patents, resulting in damage to goodwill, unfair trade practices, unfair competition, eventually resulting in commercial disputes. The next resource person Mr. B. Vivek Anand Sagar, will delve into the topic IPR and sports. And to introduce the speaker, may I call upon Dr. Gority Simoish, Assistant Professor and Coordinator, IQAC. Over to you, madam.
A very good morning to all. Yeah, I think Sir has not joined the
Madam Gority, kindly take a pause. We are just waiting for Sir to join.
Sure.
We are waiting for Mr. B. Vivek Anand Sagar to rejoin. Join. Madam Gority Simoish, may I request you to introduce the speaker to the audience?
Thank you very much, Sonali. Am I audible?
Yes, madam.
Thank you. So it gives me immense pleasure to introduce to you our esteemed resource person for today's webinar. None other than Mr. B. Vivek Anand Sagar, consultant and IPR attorney, Patent Information Center, Karnataka, State Council for Science and Technology, Bangalore. Well, year 2012 was very special for Mr. Vivek Anand as he successfully completed his master's in business law from the Kuvempu University, Gyana Sahyadri, Shimoga, by securing a first rank. And later in the same year, completed his postgraduate diploma in human resource management from the same university. Thereafter, in the year 2014, he successfully completed his master's in sociology from Kuvempu University again. He has done his PG diploma in human rights law from National Law School of India University and is currently pursuing his PhD on the topic enforcement of copyright issues in film and recording industry at CMR University. He is an international consultant for Kunming International Arbitration and Mediation Service Center, China, and is independently practicing as an advocate in Bangalore in the field which is very close to his heart, IPR and civil litigation. He is a guest faculty at Ramaiah College of Law, Bangalore, as also a consultant at Karnataka State Council of Science and Technology, Bangalore. He has also donned the designation of honorary as a research associate at the Center for Intellectual Property Rights Research and Advocacy, CIPRA, and Ministry of Industry and Commerce, Government of India on IPR from the National Law School of India, University, Bangalore from August 2012 to March 2018. Well, as part of research team at the National Law School of India, University, he has been involved in publication of the IPR law newsletter. He has been involved in organizing various national and international conferences as part of CIPRA and Ministry of Industry and Commerce Chair on IPR at the National Law School of India, University. He has also been actively involved in legal research project and has submitted comments on draft of the Data Protection Bill. These papers and articles have been published in various books and journals, and Sir has also delivered talks on the subjects of intellectual property rights by the Ministry of Micro, Small and Medium Enterprises. Today, Sir would enlighten us on the topic IPR and sports. Over to you, Sir. What happened?
Thank you for that wonderful introduction
Over to
of
you,
mine.
sir. B. Vivekanand.
Can you hear me?
Yes, sir, you are audible.
Yeah. It was a wonderful presentation by Simos. Thank you very much for the presentation. Sir. I'm really glad to be part of this particular program. When I got this particular invitation from the professor that so-and-so program we are organizing from the college, I was really very delighted and happy. And I was also very much honored because Professor Sairam sir had referred my name to be as a resource person or the part of this particular program. I would also like to thank Professor Sairam sir for this opportunity, as well as the college to provide me this opportunity. As you all are very much aware that today the sports has no longer been as a game. It is not only used as a, sportiveness or for physical fitness or various other such things. Today, sports have a various facet. A huge revenue generating business also we can call it as. And it has a lot of interfaces with respect to a lot of technological interfaces, legal implications, and various innovation has been taken place in the sports. We being the lawyers or the legal advocates have a lot of role to play in the sports and IP. I would like to go to my presentation and share some of the thoughts which I have on this particular subject with you all. And in the due course, I would also like to keep the floor open at any point of time for you people to discuss and debate on the subject matter. So let me, with that, I would like to thank the college and I will proceed with the presentation. Let me upload the PPT.
So are you sharing your screen?
Before going to the PPT, I have a small video to be showcased. I request all the people to be very careful to understand the problem which was involved in it and the solutions. I hope you are all able to see the video. Sir, can you see the video?
No, sir, it is not audible. I mean, it's
Yes, I think it is visible now, sir.
now it is.
We can have some response from the host. Can you see the video, madam?
It is a small icon.
You're yet to play it, sir. It's the
You
screen
too.
is visible.
Yes. It's a cricket match. Okay, that's all which I require at this point. Hope you all saw this video. It's a cricket match wherein we have Sachin Tendulkar in the crease. There was a very quick and fast goal is what they say. Our wicket was taken. To tell me whether there was an out or not out. Can I have some chat answers in the chat box, please? In the chat box, can you just kindly quickly tell whatever happened? Okay, let me narrate the situation. It is an international cricket match happening. There is a Sachin is in the crease. There is an Australian bowler who bowls the ball. The ball comes, passes through the bat, goes near the wicket, and it's they say it's an out. Now, can you people tell me when it's a World Cup match, it's the last ball, last run which is required, and India requires only one run for this. Can you tell me whether there was an out or not out? I just wanted to tell you whether there is an out or not out. Just type and tell me out or not out. That's not out. Okay, any other persons, please? Any other people? Is it others also can put in chat box, or is it disabled? Amresh sir?
No, it is not disabled, sir.
It is not disabled. Okay, because there are at least 40 people. I just require two more. What do you say? Responses. Yeah. Okay. Srisha says not bold, not out. In my opinion. Okay. If this is a case, usually after this situation, the umpire is the umpire who's in the ground. He's not able to tell whether there's an out or not out. So he refers. He also have this confusion. So he refers to the third umpire. And the third umpire, usually what they used to do, they used to move the camera backward and forward, like rewind it back and forth and see whether there was an out or not out, right? This was a methodology. And various times there was a situation because there is a very short time we have, and within that decision has to be made. Many a times the decision they would have told that yes, it is an out, and later they would have examined and say, hey, come on, it was not an out, right? So this kind of situation when there is an international match happening becomes a big problem, right? So what should have been done, or what could have been done? Let me show my PPT. I hope you are able to see the presentation. Madam, are you able to see the PPT?
Yes, sir. Yes, sir. It is visible.
Should I make it full screen? Yes, let me make it full screen.
The text isn't visible.
Madam? Are you able to see the slide which there is a wickets?
Yes, sir, it is visible.
Okay, done. Super. Yeah. So this was a situation during this wooden wickets. So the major problem which we had was accuracy in the decision making, right? Accuracy in the decision making was a greater problem in this particular match. So what happened? What was the innovation which was brought in? And how this became a successful revenue generation model? That's what I need to tell. Can anyone say what is this? What did this solve? What kind of problem did this solve? Madam, I'm not able to see the chat. I request you to kindly read out the chat box with the name who is posing the that answers. Yeah. Some response, please. Yes. Should I repeat the question?
So please repeat the question, sir.
The question is, madam, the present day, this kind of wickets which is being played in the various international or national or IPLs or whatever pills must have seen, right? So what is the breakthrough which they made and what was the innovation? That's my question. What is a simple solution which they made? Okay, that's the question. Yeah. What is the simple solution they made?
So one of the participants says lighting bales, or one of the participants says bales with the lights.
Wonderful, wonderful. That's more than enough. Madam, we and you all studied in our high school a small basic principle. What was that science which we studied in the high school? That the sound, the light travels faster than the sound. That's a basic principle which this particular inventor, Mr. Bronte, who adopted. What did this person do? He invented this a system for indicating movement of article from one position or orientation to another position or orientation. What do you mean by this? He is an inventor from Australia who is the director of Zinc International. He made stumps which are so touch sensitive and blink whenever the bales are taken off. The sensors in the bales are determined within 1 of its 1,000 seconds when the wicket is broken. So once the wicket is broken, the bales immediately flashes and the LED lights glows, and there is the signal which is being sent. This is all which he did. Let me further explain what was a patent, what was there in the patent. Dear madam and sir, this invention had a LED bulb, low voltage battery capacity, and a sensor. Only 3 components: battery, sensor, and a LED bulb. This combination of the product which he implanted in this particular thing and made a program to such a fashion that it will give indication or an intimation or a decision with 1 of its 1,000 seconds. That is where his invention lies. What he did, he filed a patents, and his patent application number is, you can find that WO, that is, it's a WIPO patent which he has filed, WO 2011 044642A1 is a patent number which he had secured. So now he made this particular invention. This is his application number, how a patent application looks like. He did not stop to file an application in Australia, but he also filed application in India. Why he filed application in India? That's my question. Yeah. Can anyone give an answer why he filed an application in India for a patent? And his application number in India is 1168/KOL is Kolkata jurisdiction patent office he has filed, NP/2012. In the year 2012 he has filed. Can anyone tell me why he has filed a patent application in India? Yeah, that's my question. Madam, If anyone would have put the chat answers, can you read out that?
Yeah, I would do that, sir.
Thank you very much.
Waiting for the responses.
Yes, madam. Can anyone say quickly why he has filed patent in India? Any answers?
There is one response
by whom?
from Dr. Amresh Kumar.
Okay.
The response is it is to keep his invention under IPR.
Okay. Correct. Correct. Any one more response? One more. Yeah. Any other responses? Okay. Nevertheless, as you all.
The second response says that so that no one can use it without permission in India.
Wonderful, wonderful. Who said that?
This is from Maheshwar Bhangi.
Very good, sir. Mahesh sir, you're absolutely right. Why? The reason is, yes, please. Sorry? Can you repeat? Someone, I think someone is answering.
Any more responses?
No problem. I think someone has opened their mic, so kindly mute that. No, not an issue. As you all rightly pointed out, and sir and Mahesh sir also rightly said, sir, intellectual property rights is a territorial in its nature. What do you mean by territorial in its nature? May I request someone who has opened their mic to kindly switch off, please?
Other than the speaker, others please disable your mics. Kindly disable your microphones.
Hello, sir. Can you kindly disable your microphone, please?
Kindly disable your microphones.
Okay.
Lovely ma'am, kindly requesting you to mute your microphone, please.
Oh,
Lovely ma'am, can you hear me? Please mute your microphone, ma'am.
Yeah, thank you. Yeah. So as I said that, so intellectual property rights is territorial in its nature. That means this particular inventor who sat years together to see what is the problem which is happening in the cricket match, especially when there is an out or not out, which decides the entire winning or the losing of the whole match. Hence, this particular inventor saw and brought this particular solution and thought of this and made this particular product, filed a patent in Australia. Thereafter, he also files a patent in India because universally intellectual property rights are territorial in its nature. That means if you want, as Mr. Mahesh sir said, if you want, okay, now the question is, sir, it is just a sensor, a battery, and a LED. Anyone can do. Any computer science engineer would, if they can fix this particular problem, may not be so accurately, but at least nevertheless they could do this. But to stop others from, see, if you have an idea, if you know the formulation of today, the Covaxin or Covishield, anyone will be able to manufacture with respect to the pharmaceutical industry. In a similar way, if a computer science or a engineer or a information technology engineer, they would be able to easily fix this particular problem if they have this particular product and it's already described in the patent application that what are the capacity, how does it respond, how within one of its 1,000 seconds it can respond and give you the result. So all these things will be described. Anyone will be able to see this particular application and use it, right? So to stop others from using, to stop others from infringing, to stop others from pirately using my product without my permission, and to do so because it is your intellectual property. Primarily the intellectual property philosophy of intellectual property rights primarily is that to reward the inventor. If someone easily copy and use, then what is the fun in I need to invent? Why should I invest my hard labor? Why should I invest my intellectual labor? Why should I invest my capital on invention? Right? So this is a big issue. And that is where the philosophy or the principles of IPR, the first principle is that it is to reward the inventor. You come out with an article, if someone copies it, then isn't it, it's unfair? Isn't it, it's a copyright infringement? That is where we say, if at all, if you wanted to use someone's work, acknowledge it or give a reference for it, that this portion is being taken from so and so portion. That's how we do in the article writing, right? So in the similar way here, to stop others from infringing your right and to reward for the invention you have made, the first principle is that the intellectual property gives you a reward. Second one, at the same time, it gives you a recognition that Mr. Vivekanand Sagar is the author of the respective book, or he is a so-and-so inventor of the so-and-so work. So that's where it gives you a recognition. At the same time, this also generate revenue for you. How? Sir, today this particular wickets which is there, can anyone put me just, I just want 3 response, compulsory, yeah? That, what is the cost of this wickets? Yes, that's my question. This wickets I showed you, right? Can you tell me what's the cost of this? Quickly. Random answer. You did not, sir, we don't purchase this kind of thing, sir. It's all about wooden wickets and other things we use. But nevertheless, can you tell me the cost of this? Quickly, please. I want 3 response compulsorily.
Sir, 2,000-3,000.
Okay, done. 1. Next. Second answer. Quick, please. I have 35 minutes in which I have already exhausted 17 minutes. Please, quickly, there is many more interesting cases. I need to discuss that.
So around 5,000.
5,000 to 3,000 to 5,000. Okay, last response, please. I want this. What's the cost of this?
There is a response in the chat box.
Yeah.
Dr. Amrish Kumar says it is 30 lakhs. Astrid Fernandez says it is 50 lakhs. And Maheshwar Bhangi says it is 25 lakhs international.
Wonderful. Sir and madam, what is the difference from 2,000, 3,000 for a small component of LED bulb, a battery and a sensor to 30 lakh and 50 lakh? Does it make sense? Is it possible? Is it true? Can we believe this? If these are your questions, I absolutely say 100% you can believe that this, the amount what sir said, that 50 lakh or 40 lakh or whatever lakhs, and this amount is not for the selling of the technology, sir. This is not for selling of technology. The Bronte's methodology or this company says, if you wanted to use this particular wickets, you need to purchase 4 sets of the wickets for a match which is happening in Bangalore Chinnaswamy Stadium or in Goa, which happens in a particular stadium. You need to pay for that. And that product is not for sale. It is only for use. That means you can use these wickets only in that particular cricket stadium only on 26th on July 2021 or June 2021. That is the condition, and he says it is 45 lakh rupees for the said product to be used. And for any other matches happen any other places, every time the meter runs. This is possible because of intellectual property. This is possible because of patents. The patent gives the right to make, use, sell, offer for sell, and export your inventions. And that is where patent is having a strong protection on intellectual property rights with respect to various technological interface with sports. With that, I wanted to surprise you that intellectual property rights is not so simple, and it gives a huge amount of revenue. So just a small invention, this particular inventor did, and he just reaps the benefit. You all know J.K. Rowling. She wrote Harry Potter book, right? Her book, when she presented her manuscript to the 5 publishers, they threw her book and said, who the hell will read your book? But today, her book is being translated into hundreds of languages. Her book is being transformed into movies. Her book is being translated into hundreds of languages, sold in crores number of copies. Digital copies are available in the internet, and various character which comes in her story having a huge amount of revenue. Today, she earns crores together of money, right? How? Because of the copyright. The copyright protection provides rights to the creator of the work. right? So this is the potential of intellectual property rights. There's a greater opportunity for all of us to dwell and to deal with respect to intellectual property rights in the sports specifically also. I have few more case studies. I'll just quickly take you through that and also to understand that intellectual property rights means it is a creation of mind or an intellect. It may be with respect to an invention. It may be a book which you have written, a painting which you have drawn, a song you have sung. Can anyone recognize what is this? La 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 le le o, la 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 le o. What is this? What sound is this?
Kingfisher.
Yes, wonderful. Madam, I did not tell the name. I did not tell the product. You did not see what is a product, but just by the sound you are able to recognize it. And it is Kingfishers. How? Because there is a protection for the songs of this particular sound under the trademark as a sound mark, under the copyright for the songs. Or the symbols, today IPL or the Chennai Super King or various names which are all there, right? Which has been given for each team from different states. So all these are entitled for trademark protection. At the same time, the names, the images, the design, the lions roaring, which is who has this lion in the cricket match? Which team has this lion? Can anyone say which team has this lion? Or which team has the bull?
There is a response. Astrid Fernandez says it is CSK.
Then, yes, next. Who has bull? All those graphics which are being put up in the cricket match, right? All those things are entitled for copyright protection. Okay. Likewise, this intellectual property rights is a kind of a legal right. It's something like you have a property 30-40 site in Goa, in Marba, so that means what? You have a legal right over the property. That is a tangible property. This is intangible property. Intellectual property rights are intangible properties. And they are territorial in its nature. As earlier when I posed, why you should file a patent in India for an invention with respect to cricket match? Okay, can you tell me quickly one question? If at the same time, this particular Bronte, should he file a patent in China? Should he file a patent in China? That's my question for this particular wickets or the system. Quickly, yes or no? Answer. Should he file a patent in China?
No.
No. Why?
No.
Why?
Because there is no cricket culture in China.
Wonderful. That means if you are the inventor or the creator, or if you are the advisor for these innovators and creators, when we advise and when we say, sir, we need to protect our inventions, and then we will chalk out as to which are the countries where I can file patents. So that is where we have PCT route, that is Patent Cooperation Treaty route. Under Patent Cooperation Treaty route, you can choose 153 plus countries who is a party to this PCT and choose any other country by sitting in India and filing a patent application primarily in India first, and then you can choose any other countries where you feel that your invention has a relevance, where you feel that your invention will be copied, where your invention has commercial gain. This is what you need to decide upon when you go ahead for protection of our intellectual property rights, right? Likewise, so they are territorial in its nature. If you want to protect, then you have to follow the respective country's procedure and pay the respective fees and get it protected in the respective territory. If you have not filed patent in the respective country, then there is no point in, if there is no requirement to file a patent over there, because there is less likely for people to use it, right? So then you need not file patent over there. So altogether, today I have told you a best example about the patents, trademark. I have also given example, copyrights, design for the cricket ball or the match, layouts, right? Or the cricket bat, helmets, guards. All these products have design protection, geographical indication, trade secrets, very important for a sports, because in sports, it's morely about the strategy. It is morely about the management of a game. What is the next strike which he is going to do? How we should take a defense? So all these things have a major role to play in the trade secrets, where the coach who knows how the strike has to be done, and that is where he guide. So that are the ones which we can go for trade secret protection. And we have integrated circuits and layout designs as a part of an intellectual property. Plant variety does not come under the sports, but nevertheless, that's also another category of IP. So GI, let me not explain about GI because not much relevant for the present session. So here it comes about the copyright. Copyright is an exclusive right granted to the creator on expression of an idea. Copyright owner has a right to reproduction, translation, adaptation, distribution, and publicize and display the work. So there was one important case about hot news doctrine. What was this hot news doctrine? Now, usually, who is the one who purchases the broadcasting of the cricket match which happens? Who purchases the rights for broadcasting?
Broadcasting agencies.
Who gives the license? Who gives the license and who purchases it? Two questions. Okay, fine. Plainly, who is the owner of a cricket? Who is the owner of a cricket?
BCCI.
Yes. So the BCCI is the owner of the cricket, and they have, because that's a council which is established in India to administer and function with respect to the cricket. So they are the owner of it, and they have the rights over the. Sorry. Yeah. So that's where I was telling you. So they are the one who are going to issue the license for broadcasting, or the will be done. So who purchases usually for the broadcasting? Who is the player to purchase the said broadcasting of the cricket match? Who broadcasts the cricket match? Okay.
Sony Sports.
Yes, wonderful. Sony Sports or Sports and various other sports channel, hot stars, etc., are the ones which are being agencies to broadcast a cricket match. So this Star Sports, earlier it was in the Star Sports which purchased the rights from the BCCI, and they telecasted the they broadcasted the cricket match, and it used to come in all our TVs, televisions, etc. But do you remember in the year before 2014, what used to happen? That the cricket match, once the match has been left online, the Airtel and other few telecom companies, what they made, they sent an alerts to the customers of their customers that there will be a ball-to-ball information given whenever there is a wicket out, because every time you cannot sit before the television to watch because you are all moving around, working around. So sometimes, but you would like to know whether there was an out, what was the score, who is a next bowler, who is the next cricketer, so who is the next batsman, etc. You wanted to know. So this the telecom companies, they sent an information to the customer stating that if you want, we will send you the alerts, and the package is 30 rupees. Have anyone used this? Yes or no? Have anyone used this earlier in the cricket match to get access to this particular alerts, news alerts, cricket alerts, ball-to-ball information? Yes or no?
No, sir.
No, sir.
No. This was there. This was there before 2014. Or you must have also known. Okay, fine. If you have not known about one more thing, in the Doordarshan channel, the news used to happen at one place, and the same cricket match used to come in the one of the border of the whole screen. Do you know about this? Some side, left or top, bottom, sometimes at the back. Have you seen this?
Yes.
You have seen this, right? So this, when they made this, the BCC. Hello. Please, I request. Yes. So as I said, that this kind of situation was happening, and the BCCI filed the Star Sports filed a suit against this telecom company that you are not supposed to send an information or alerts on a charge basis, because broadcasting of the said cricket match, the rights are with us. If you start sending information to the customer, will anyone see my television? Will anyone see my channel? If it does not come and see my channel, how and people has to see my channel and view the advertisement, and that is how the revenue I make. And if people does not come and view my channel and get all alerts in his messages in the mobile phone, then what is the fun in I purchasing the broadcasting rights of the cricket match? And the court said that yes, that is also correct. But the opposite side was that argument was that, sir, what have you done? It is a cricket match which is happening in India. It's a World Cup match, and people all over the nation, they are all very eager to know about the cricket match, what's happening, etc. And they would like to get this information. Otherwise, it's a national game, and people wants to know about it. And if you wanted to curtail like that, it is very bad. You're curtailing the right to access to the information for the people. So that was a point which was argued, and the court said that yes, but it is a Star Sports which have taken the rights of it. Hence, if at all, if you wanted to display, there should be a relay. If you know, earlier you must have seen first the cricket match, who is an out, that would have come in the Star Sports, and after a few seconds lag, right, then the other channels used to display. This is what the court said that okay, fine, because in the interest of nation to provide information, which is a national game, hence okay, fine, let Star Sports be the first to release, and there should be a lag of 3 to 5 or 6 seconds, and then other channels can release. This is what they said, and the court said this as a hot news doctrine. What? Hot news doctrine. What is a hot news? Because today everyone wants this news to get an alert or update immediately. Hence, the telecom company started sending messages through on a package of 30 rupees or whatever it is. So this, the court said that yes, they cannot do so with respect to that hot news doctrine, because it is the Star Sports who have purchased the rights of this particular cricket match. And ultimately they said, sir, what am I telling? I'm telling the fact. Who was an out? I told the fact. When I'm telling the fact to the people, why should you give a copyright protection for the fact? Or, sir, it is not a film somewhere where you have staged everything, okay, and taken a film, and then we can say that yes, people, it should not be copyrighted or it should not be copied. But what is this? This is not a fact. It's a real game. It's a fact. It is a situation. If someone gets an accident in some place, the news reporters or news television channels will report that there is an accident which has happened. Can I say, no, I have covered this fact and no one should display that? How can this be a logically reason? And the court said that, yes, of course, it is a fact, but the rights are being sold. So the right, which is called as broadcasting right, or rights of data, like when did the score, what is the score, etc., etc. Sir, how many minutes do I have? Madam, how much time do I have?
So you can continue for around five more minutes.
5 more minutes. Excellent. Good. So this is and that is called as data rights. Okay. So the cricket match data, the broadcasting, or the personality right. You know, the personality right is also another such rights which is there in the copyright. So this copyright is, actually speaking, copyright is not mandatory for registration. Is a cricket match registered that I have a copyright? No, it is not necessary for, or an articles, you must have written a lot of articles. Do you have a right over the, do you have copyright over the articles? Yes, of course you have a right, but you need not register for the copyright because it is an automatic right which will be granted as soon as a work comes into existence. Okay, at the same time, we recommend to register because if you register, we have a conclusive proof on our hand that I am the owner of the said work, right? So there are various works, as I said, under the copyright, like literary work, books, essays, computer program, data sheet, okay, compilations, artistic work, drawing, logo, maps. You know, in the cricket match, there is no various logos.
Already, yes, sir.
The map, the chart, photography, okay, work of architecture, the music, sound recording, cinematography, etc. Yeah, very importantly, you know, this our 5 rings connected, okay, Olympic Games. So this is a trademark. As I was telling you, a trademark is in the name, the word, like Adidas or Godrej, Google. All these are the various names, word, sound, number, color, taste mark, fragrance mark, you know, for this fragrance for this particular ball which they used to use in this golf. So it has a various different fragrance of grass. The ball had the fragrance of grass, and for that fragrance of the ball, and by smelling it, you would know that this is a company which has made that particular ball. So that was given the trademark protection. The symbols, the logo, right? And trademark is protected for 10 years. Every 10 years you can keep on renewing it, right? So this gym, Gold's gym, it's also a registered trademark. So if you have seen wherever places where they have put R in a circle, it is registered. If there is a TM in a circle, then it is trademark applied but yet to get registration. So there is various process. Very importantly, as I said, it is not only the technology, the technological interface. As I said, a patent is an exclusive right granted to the inventor. Okay, and this right to exclude others from, that is to stop others from making, using, offering for sale, selling, importing your invention. That's the primary right you are going to get in the patents. So how to get a patent? Simple. Then you need to satisfy 3 major criteria. First, the invention should be novel, or it should be. Third,
I'll call you after 15 minutes, but I'll send you the number.
Third, it's an industrial applicability, and patent is valid for 20 years. That is from the date of filing of your invention, not from the date of grant. From the date of filing of your invention, you will have 20 years of protection. So this is what under section 21J of Indian Patent Act 1970 speaks about the invention. And there are certain inventions which is not patentable, like any invention which is contrary to the public order or morality, or method of treatment, a mere admixture, or anything which is business method. Sir, someone was telling me that, sir, I have a wonderful game which I have come out with, a new game which I have come out with, like PUBG and various online gaming today. You see, right? There is a huge business revenue generation today. They have been making, must have received a lot of applications online, right? So, sir, you say, sir, I downloaded the respective game. It is for free, sir. If you think it is for free, you're wrong. You are giving the data currency. You're giving a different currency, that is a data currency. You give access to your information. Your information itself is a data, and that data is having a value, and that's what is happening. So a new game you have brought out with, you will not get a patent. A new business model you have made, you will not get a patent. A mathematical calculations you have made, sir, you say, sir, next match, this is how it happens, and who is going to win the cricket match, and that's the algorithm which I have made. I know if he plays in this particular ground, he is going to lose, etc., etc. I have made everything. Can I get a patent for it? They say no, sir. Right? So there. And how do you file a patent application? There's a small process to file an application. Not a small process. It's a huge process, and it's a huge cost is also involved in patent filing. So there is a patent professional who files a patent application, and it will be examined. If there is no objection to be granted, if it is an objection, then heard, and then whether it should be granted or rejected, they are going to decide upon. As I said, trade secrets, techniques, game strategy, the methodologies, the strength and weakness analysis, all these because the coach has an excellent secrets about the game. He knows what is the techniques to be used. So those can be protected under the trade secrets, but we don't have any specific law for it. But it is trade secrets is something which is in a contract basis. They say, for example, if you have coached this particular cricket match in India, you should not be teaching some other country cricket team, because you may tell the strength and weaknesses of this team to them. So there will be a bar through contract. So there is only a contractual obligations to stop this kind of trade secrets. So designs, especially, various equipments in the cricket match, or whether it may be a guards, it may be helmets, etc. All are entitled for industrial designs. So industrial designs, the primary requirement is it should be eye-catchy feature, it should be new, applied to an article in an industrial process. It should not be a functional feature, because functional feature get protected under the patents. It should not be an artistic work or painting, because it goes under copyright. A very interesting one. See, can you tell me, sir, if you have come out with a new medical formulation for an eye rashes or some kind of a problem, then you can get a patent for it. You have a logo on the product, you can get a trademark. You have a design of a bottle, you can get a design protection. And what is this? What is this? This is my last 1 or 2 slides. Can you tell me what is this? What protection will you go for? Some answers, please. Patent, copyright, designs, trademark. What protection will you go for this? I hope you are able to see this. Any answers? Madam? Am I there or?
Any questions from the audience?
No, not questions. I'm asking for an answer.
Any answers from the audience? I'm sorry, sir. Beg your pardon for that.
Yes, madam. Okay, let me tell you. Sir, there is a problem, whenever you take this eye drops to your eyes, there's a natural tendency of the eyes to get closed. By this, the medicine get wasted, right? So here the particular inventor made a small system. What is that? This is a small system where to stop your eyes from blinking while administration of medicine. And for this is not a design, this is not a trademark, this is a patent protection. Okay, so this is a patent protection. You can get it because it's a functional feature which is there. And your user guide or manuals can get to go for a copyright protection. Some of them can go for trade secrets as a supplements, etc. A mobile phone can explain all kind of IP. Okay, there is a trademark. There is a lot of technology which is there is hundreds of patents in a mobile phone. There is one trademark. Thousands of songs get copyright protection. Design for a shape of a mobile phone. Apple versus Samsung, when they used to fight in US and etc., that they said a huge amount of damages was being granted for design patent. In US, they call it as a kind of weird for me. They say it's a design patent. So for the curve shape, Apple phone curve shape is there, right? For that, they have taken a design patent. And the Samsung copied the said design. And they filed the suit and fought for it. But they did not file in India because in India, there is no protection for called as design patent, but we have a industrial design protection. So that's all from our side. And all that which we say is that in intellectual property, be innovative, think out of the box, don't buy the fake, produce original work. So that's all from my side. I would like to thank the institution organizing this particular program. I would like to thank Professor Sairam sir for providing me this opportunity. I would like to thank all the participants for their kind and patient hearing and bearing with me with all the questions to answer, etc. and etc. So nevertheless, I was really very happy, and it's a wonderful day for me to start with this particular lecture. So thank you once again, everyone, for this opportunity. Thank you.
Thank you, sir. Rightly said, intellectual property is the creation of the mind and therefore needs protection. Sir, your presentation was very informative and engaging. Thank you for effectively dealing with various aspects of intellectual property, the rights related to it, and the importance of the protection of IP rights. Thank you. We would take the question answers at the concluding session. Competitiveness and commercialization of sports and related activities has resulted in the emergence of disputes, commercial and disciplinary. Every aspect of sports today is governed by contracts, creating legal rights binding upon the contracting parties, with the objective to uphold the spirit of sportsmanship as also to protect various rights. Our next resource person is a team. Dr. Sairam Bhatt and Advocate Rohit Kamath would present the topic, Contract Disputes in Sports. And to introduce the speakers, may I call upon Dr. Shruti Nadkarni, Assistant Professor of our institution. Dr. Shruti Nadkarni, please take over.
Thank you, Sonali. A very good afternoon to all the dignitaries, resource persons, my colleagues and participants. It gives me immense pleasure to introduce before you two very knowledgeable and experienced resource persons who would speak to us on the topic contract disputes in sports. First, I would like to introduce Professor Dr. Sairam Bhatt. Dr. Sairam Bhatt is a professor at law at National Law School of India, University, Bengaluru, with over 20 years of experience in legal fraternity. His areas of specialization includes law relating to public-private partnerships, competition law, tendering contract management, environment protection, and law on right to information. He has served as consultant to several governmental and non-governmental organizations and has conducted several training programs and workshops for various officers of Government of India and other state governments under the aegis of various government bodies, including Administrative Training Institute, Mysore, National Academy of Direct Taxes, Delhi, Vizag Steel, Central Silk Board, National Productivity Council, and so on. He did his LLM and PhD from Department of Law, University of Mysore, and has been awarded Young India Environmental Law Fellowship and served as adjunct faculty at Golden Gate University, California, USA during the fall 2003. As a Fulbright Nehru Fellow 2010, he was a visiting researcher at Georgetown University Law Center, Washington, D.C. during August to December 2010. He was also Linnaeus Palm Academic Exchange Fellow at the Royal Institute of Technology, Stockholm, Sweden in 2012 and 13. He has published several books, to name a few. A book titled Natural Resources Conservation Law, published by Sage, Right to Information, published by Eastern Book House, Contracts, Agreements and Public Policy, Energy Law and Policy in India, Right to Information and Good Governance, and so on. He is also the chief editor of Journal on Environmental Law, Policy and Development and Journal of Law and Public Policy, published by NLSIO. I welcome you, sir, for today's webinar. A second resource person who will be speaking on the same topic is Advocate Rohit Kamath. Advocate Rohit Kamath is an advocate and associate company secretary with over 5 years of experience and specialization in corporate law, startup, strategic advisory, and private equity investment. He is currently empaneled counsel for the Karnataka Biodiversity Board, Government of Karnataka. He has experience in handling statutory and contractual compliances for numerous Fortune 500 companies in matters of PE transactions, foreign investments, issues of securities, joint ventures, etc. He is also engaged as consultant from May 2009 by CIRA, National Law School of India, University, Bengaluru, for a 3-year project under the aegis of Ministry of Environment, Forest and Climate Change, New Delhi. Having completed his graduation in law from KLE Society's Law College, Bengaluru in 2015, he went on to complete his master's in corporate law from University Law College, Bangalore University in 2016. He completed the Company Secretaries course offered by the Institute of Company Secretaries of India, New Delhi in February 2016. He received the scholarship for the 3rd China Law Society training base held at Kunming, China, and was an invitee to Yunnan University, China, to deliver guest lecture on Indian legal system, and also participated as resource person in State Investor Summit under the Belt and Road Initiative held at Kunming. With a view to develop his passion for teaching, he has qualified NET and KSET and is also pursuing his PhD at National Law School of India, University, Bengaluru. He has also authored numerous publications, including the book Healthcare in India, a book published by Bloomsbury in 2016. I welcome you, sir, and I would request Dr. Sairam Bhatt to take over this session.
Thank you, Dr. Shruti, for doing the honors. May I request Dr. Sairam Bhatt to take over.
Thank you, one and all. Thanks to Dr. Saba, Dr. Manoj Hegde, thanks to Shruti, Sonali, and all friends at GR Kare College of Law. It's really exciting to join a session back at an institution which I was a part of for more than 2.5 years. I was just looking at the developments from the morning, and I was just concerned about what Dr. Amrish Kumar had to say in the chat box. He was talking nothing to do with sports law. I was wondering whether there is sports law at all in India, right? And that's probably the question that we should start off with in such a webinar. Is there a sports law in India, right? And the topic that, probably I have chosen because Dr. Manoj was kind enough of giving us this choice, and he picked up what else would be relevant for this webinar. And he said, I think contractual issues in sports can be a very...
Dr. Sairam Bhatt, I'm sorry to interrupt you. You are audible, but I think you're a little soft.
Okay, thanks, Sonali. Thanks for that. I'll try to speak up. Let me see if my microphone volume is correct. Okay. Let me just, try and state the fact that contractual issues in sports are very, very important and very critical. And, we usually, when we say we do not have a sports law in India, perfect sport law that governs all aspects of sports. And when you look at it from a constitutional dimension, it can come under the concurrent list, and even the state and the center both can actually legislate, but probably they have not legislated a complete comprehensive umbrella legislation on sports. Obviously, what you do is to look at allied laws. You look at laws that are applicable to each aspects of sports, right? That's what it is. And contract law is a foundational law, and I think contract law actually is something that governs the basic relationship between two individuals in a given society. And the law in India, which is the Indian Contract Act 1872, is quite an interesting law which poses a lot of numerous challenges, as it were, to contemporary times. Because in contemporary times, you will notice that contracts are not very simple. They are quite complicated, and they can be quite unfair, unjust, and probably arbitrary as well at that point of time. So what are the contractual issues in sports? Friends, the presentation that I'm going to offer to you is just an eye-opener, and I hope that you will get some insights when you go or dig deeper into this particular topic. And you will notice that these issues are not unique to India. They are there in the West, they are there internationally, and it is going to probably increase for the simple reason is because sports in India is now getting globalized. Thanks to the different leagues that we have and different tournaments, I think the sports in India is up for some exciting times as it were, as we discussed today. So let me see if my presentation is going to be visible, because Anand's presentation was not moving. It was stuck to one slide. So I will try and see if I can share my presentation, and I'll try and see if it is something that I can keep moving around. Okay, so friends, quickly in the given time, obviously I'm not going to go into detail of any of these because the details probably can consume a lot of time because there is a lot of scope and ambit in terms of the application of law and issues in sports. So the first and the foremost, we start with the challenges that are there vis-a-vis, somebody who goes to a stadium and watches a sports match. Let's take the Indian Premier League because sports, in India is quite popular with cricket. Cricket happens to be probably the only sport that we often discuss in sports law. But don't forget that there are other forms of sports that are becoming very popular. It is attracting people to the stadium, and people are paying for watching these kinds of sports. Cricket, interestingly, is very, very popular. It's quite rich. It's probably the richest sport in India. Why? Because fans are actually going to the stadium and they're buying tickets to watch a match. Now, the Indian Premier League, as you know, is pretty popular. It's already past its 10th edition. There are franchisees that are working over here. Fans go in the evening. They have a 40-over kind of a game. Obviously, the appetite from 5-day test to a 1-day international, and then coming to a T20, I think there is a lot of appetite for people to watch it, not only on television, but in the stadium. Now, interestingly, you will have IPL as the organizer and the fan going to the stadium. Now, where are the contractual terms and conditions written in the ticket? Obviously, you will notice that the ticket is a very small kind of an evidence. And you will notice that the courts have said it is only an evidence of the contract and not the contract itself. And what does this ticket do? Obviously, it will have 1,000 rupees or 5,000 rupees or 10,000 rupees. I don't know if anyone of you have got an opportunity to go to a cricket match, because I believe Goans like football, not cricket, which I think is the right thing to do. But nevertheless, I think, and I don't think Goa has hosted a cricket IPL match. So nevertheless, once you go over there, generally the entire terms and conditions are then said to be on a website. Right, so the ticket will say go to www.ipl.com for the enlarged terms and conditions. Now, when a fan decides to buy a ticket, he expects a kind of a match that happens. Now, who decides the terms and conditions of this kind of a contract? Now, one would say, sir, would you put it as an implied contract or an express contract? In either sense, the relationship that binds the fan and the organizer is to be governed under contract law, right? Unless you have a special law for such kinds of purposes. Now, very often than not, if you have seen IPL terms and conditions, these are conditions that are decided by IPL. They're one-sided. They decide what is suitable for them. They will have all exclusions, all disclaimers. And in 2017, the IPL ticket had a very interesting clause, which I think I will discuss over here, because I thought it's not possible to discuss all the clauses, but I think for the webinar, one of the clauses could be very interesting for our discussion. And that is, it said in 2017, please note, it said something like this. You as a fan or somebody who has purchased an IPL ticket will not get a refund if one ball is bowled. So out of the 40 overs, if one ball is bowled, you will never get a refund of your IPL ticket, right? So it may be a 5,000 rupees ticket. It can be a 50,000 rupees ticket. For example, in Bangalore, we have what is known as the Malya stand in the Chinnaswamy Stadium. The tickets range anywhere between 5,000 or 50,000 because it comes with a lot of perks and luxuries, as it were. You will not get a refund is what this terms and conditions says. Now, many of us think, okay, the term and condition is there. I've already bought the ticket. I've gone to the stadium, and probably I'm bound to this terms and condition, right? Because that is what a contract is. Obviously, what does the contract say? You have to be above 18 years of age. You have to be of sound mind, and no coercion or undue influence has to be there. So the contract is enforceable by law. The point here is, friends, you will notice that under the Indian Contract Act, can there be judicial review of sports contracts? I repeat, can there be judicial review of sports contracts in India, right? Obviously, you will say, why not? But the real issue over there is, if you read section 23 of the Indian Contract Act, it says that the courts can actually review any contract on the ground if it is opposed to public policy. Right? This is probably the most dynamic word in the Indian contract law. Courts can decide whether a contract is opposed to public policy. That's what section 23 of the Indian Contract Act says. Now, what is public policy is neither defined, and probably the courts have tried to attempt to define it in several occasions, but the judges have also said it's like an unruly horse. Probably you can't tame it, you can't define it. What is public policy in 1916 need not be the public policy in 2010. What is public policy of one generation need not be the public policy of another generation. What is public policy in Argentina for football need not be the public policy of football in Goa. Right? So public policy is quite dynamic, and the judiciary or the judges have a lot of discretion in deciding whether this is in favor of public policy or this is not in favor of public policy. So this condition was challenged by a fan. He said, look, this is absurd. One ball. So I have come here to see 40 overs, and just if one ball is bowled, they're saying no refund. At least I should get a partial refund, especially if a match is reduced in overs when a rain comes, right? So Bangalore usually receives evening showers, and very often they're not. Some of the IPL matches, are reduced, right? So they reduce it to 20 overs, sometimes to some other kind of as per the IPL rules. So I should at least get a partial refund, or I should get some kind of remedy, because I don't get to enjoy the complete match. Now, the interesting fact is, if refunds are not given by organizers, if refund is not something that fans get to, as some kind of an entitlement that an organizer is supposed to give, can it be the basis for the judiciary to say it is opposed to public policy, right? So that's the real question over here. However, on the side of the organizer, if you look at the arguments that were produced in the court, they were very interesting. They said, very interestingly, they said, look, the teams are already in Bangalore. They are already flown in over here. They've stayed in the hotels. So we have incurred all the expenses of the event. The broadcasters are there. The stadium is ready. The lights are on. Everything else is there. So we have already incurred that expense, and that expense is something that the fan has to incur. So, we don't give refund to any of these, right? The expenses are already there. And hence, the fan probably also has to bear the kind of risk if a match does not have a full match and if one ball is bowled. And hence IPL probably tried to defend it with the kind of arguments and said they think that this condition is in public policy, and this should not be decided as being against to public policy, right? So these are some of the interesting challenges, as it were, that arises in sports, especially from a contractual perspective. And this is probably just the start. I thought I should start with one basic example, which I think most of us can relate to and sometimes get agitated that the contract seems to be unfair. Now, from our side as a fan, it may seem to be unfair. From the side of the organizer, it may probably be justified as pretty fair. You will also notice that if you look at the Law Commission report of 199th Law Commission report, interestingly, the unfairness in modern day contract, the Law Commission interestingly puts it into two categories, and a couple of judgments have already reflected these two categories. They say, look, when such kinds of contracts are being made, right, by IPL and organizer and numerous fans across, say, 8 cities or 10 cities across the country, they are generally called as standard forms of contract. The terms and conditions remain the same across all 8 cities, all fans. So it is standard term. Now, standard terms, interestingly, can be unfair on 2 grounds. One is called, substantive unfairness. That's what the Law Commission says. The judges have approved the same. And one is called procedural unfairness. Substantive unfairness is that the term and condition in the contract is, in a substantive way, is unfair. It's, obviously, who is going to draft this contract? It's IPL who's going to draft this contract. Naturally, IPL will go to some law firm and say, draft the contract, but protect my interest before you protect the interest of the fan. So there could be that element of testing the substantive unfairness of the terms and conditions in that contract. Second, the Law Commission very interestingly insists on procedural unfairness. Procedural unfairness is, very often than not, if you look at IPL tickets, can an IPL ticket be transferred? Suppose I buy, can I transfer it to, say, Rohit? Can I transfer it to Professor Saba or Professor Sonali or Professor Hegde in this audience? So, interestingly, IPL has strict regulations about who it can be transferred to. Can I assign it to somebody? Obviously, you don't want this to be black marketed, right? So you do not want A to go and buy and then sell it at a premium price to B. So transferability and assignability clauses are also there. They try to control even that. So, you can't say, look, I am the owner of this ticket and I can sell it to anybody whom I wish to do so. So these are some terms and conditions you will find that are probably necessary and probably justified in courts, but there could be several that cannot be justified. And that is where public policy becomes a critical factor, I believe, when we discuss contractual issues. Now, do we know these celebrities, right? This is interesting because this slide, friends, I'm going to give you a different kind of a contract, a different type of a contract, because one is the fan contract, the other is where the cricketer or the player or the sports person, he then requires an agent, right? So this is an agency kind of a contract. Now, interestingly, if you look at these 3 players, I hope you can guess all 3 of them. I'm sure if you are in Goa, you may not know the first 2, but I'm sure you know the last one. Now, sports persons are celebrities in one sense, right? They become very popular. And when they become very popular, they start playing for the national team. They start playing for, say, clubs, as it were, and they probably get some kind of a mileage. People start creating or treating them as some kind of heroes, right? Celebrities in that sense. So, many of these sports persons right now appoint an agent to represent them, right? So these are now individuals. We have people who are acting as sports agent as individually, but there are entities now. You have companies that are created as sports management companies. You have partnerships that are creating like sports management companies. What do a sports management company do? They expertise in sports law, obviously, but they also represent players. And what do they do when they represent players? They actually get them business, right? Now, what kind of business? Right? They probably get them endorsements. They get them ads. They get them, say, attending an event and giving a motivational speech. They get them, probably to play in different other leagues and clubs internationally. So this agency, you will notice, tries to bring in extra money for the player. That's what an agency does. And why do players require agents? There is a justification regarding the same, because a player needs to concentrate on his game. He's good at it. He should focus on that and not on the commercial side. You probably need a professional person to engage in the commercial side of it, deal with it, manage it, and so on and so forth. So it is very normal in India as well for players to appoint agents. Now, interestingly, this is also a contract. Right? And you will notice that even Wayne Rooney had agency and he ended up in trouble, like Zaheer Khan and Yuvraj Singh also did. Now, both Zaheer Khan and Yuvraj Singh went to the courts in India. Wayne Rooney also had to go to a court. Now, what were the contractual disputes, as it were, friends, in these cases? You will notice, friends, naturally, the agent again knows how to get a contract done from Zaheer Khan or Yuvraj Singh, right? Zaheer Khan and Yuvraj Singh probably are not very well aware of law. They have not probably studied contract law. There is a document that is given to them. It is explained to them, and their signatures are sought. Now, what will the agent do? In most cases, the agent tries to protect his interest, his business interest, and hence, very interestingly, you will notice that contract lawyers are very, very creative in the contract. They say, look, I will be your agent for 2 years, right? However, I will insert a clause called the right of first refusal clause. This is the clause that was in contention. And in that clause, I will get the right to continue to represent you even after 2 years. And that is the kind of continuation clauses that they incorporate in the contract. Interestingly, friends, you will notice that the Indian contract law is just an enabling legislation. It tells you which contracts can be enforced and which need not, but it does not give you the details of every clause. And hence, whether a clause is enforceable or not in a court of law is something that the judges and disputes such as these actually bring to the limelight, right? So the right of first refusal clause is pretty interesting, friends, because if you look at the Indian judiciary, it has said that if it is a B2B contract, sorry to make it a little complicated, but I think you should know this. If it's a business-to-business contract, right? If it's, say, between Infosys and American Express Bank, just imagine these are two business houses. Then a right of first refusal clause is valid and enforceable. It's possible. A right of first refusal clause is valid in something like a shareholders agreement. It's fine. But when it comes to B2E contract, that is business to employment, or something like an agent to player contract, the right of first refusal clause will be very strictly scrutinized because it has an element of being unfair. It forces people like Wayne Rooney and Zaheer Khan and Yuvraj Singh to continue with the agent despite they not intending to do so. Right? So I think there is a very strict scrutiny of some of these clauses that tend to favor the agent, that tend to favor the organizer, and that is what the judiciary will try to temper down, moderate, and balance the interest of these celebrities and players so that contract becomes fair and becomes in favor of public policy. Let's go further. You will see another type and category of a contract, and these contracts are called as franchisee contracts. Obviously, friends, you will realize that in India today, different kinds of sports are creating franchise model of playing the game. Now, do we see franchise model in cricket? Yes, you do see that. Do you see the franchise model in kabaddi? Yes, you have already seen kabaddi having franchise model as well. Do you see franchise model in football? I'm sure you can all relate that. It's already coming into place. It's already come to badminton as well. This is interesting. It promotes sports in a very unique manner, in a sense that it brings in a lot of private players. It's not only the national board or association that is playing the game. It actually expands the scope of the game to into a decentralized format, right? So the franchisee model is a very interesting model. IPL actually popularized the franchisee model. Now, what is this franchisee? Again, it's based on contract. Interestingly, suppose you have BCCI and that creates IPL, and then what does the IPL do? It creates around 8 teams, right? You have Mumbai Indians, you have Chennai Super Kings, Delhi Capitals. These are the names of the teams that are created as franchisees. Now, these teams then can have their own players. Right? That is the kind of model that is created in franchisee contract. Now, can such contracts get into trouble? Can they get into disputes? Obviously, yes, we have already seen that with many such franchisees of the BCCI IPL format. We have seen it with the Deccans. We have seen it with the Tuskers. Right? These have been disputes that have been taken, and they have been challenged based on certain kinds of actions that were coming from the contract itself. Now, in a franchisee contract, friends, there is a franchisor, there is a franchisee. Obviously, franchisor is the board. Then you have the franchisee, which is the teams, and they are having several terms and conditions. The contract may be for 10 years. It may be extended for another 10 years, possible. There are issues about intellectual property. It's about so many issues about disciplinary aspects. It is about how the team management can actually enter the players' arena. It is about match fixing. It's about so many issues and challenges, friends, because the franchisee contract is a very detailed document. That is the document, that is the evidence that governs the relationship between these two parties. And unless this document is nicely drafted, nicely crafted, disputes are obviously going to happen, because you will notice finally it's not about your impression about the game or about the sport. It is about the document that the judges will try to interpret, construct in terms of the dispute resolution that goes between these two agencies. Right? So this is also an interesting episode, because you will notice that this kind of franchising model for the first time brought in what I call in contract law as the auction model. It is quite unfortunate. At some point of time, we only used to say in contract, as I used to teach, at least in the class, that auctioning was only of goods, right? Because that is what Section 64 of the Sale of Goods Act said. But now you have players being auctioned, right? That model of auctioning where you say, I have a reserve price of 1 lakh or 2 lakhs, and then I get sold. But again, it is about whether you're available for that season, whether you have played all the games, whether you were injured. All of these are terms and conditions that are very nicely laid down. And that is, again, a kind of a very interesting contribution that contract lawyers generally engage in the sports era. Let's go further. Do we come across disputes in terms of endorsements? Yes, very interestingly, you do have, and this is again from what is available in terms of disputes, and this is interestingly towards arbitration as well, because players generally engage in a lot of endorsements. They endorse say products, they may endorse apartments and builders as well. Unfortunately, MS Dhoni was involved in a couple of controversies. Maybe those controversies arise for 2 reasons. One, probably your agent is not good. That is one of the reasons, and he has not got you a good deal. But most importantly, I think very often than not, if the contract is not adequately and properly negotiated, obviously these are going to result in a lot of disputes. There is going to be differences, obviously, that arises when these things happen. Now, what happens in the player endorsement deal? You will notice that the player has to, in many of and some of these contracts, he says that in a year, 10 days I will give to this company. I will be engaged in this company. With this company, I will come to your shoots. I will come to your publicity events. I will be there endorsing this product, right? It could be 10 days, or it could be so many number of hours, or it could be one shooting and several. So it's about endorsement. It's about saying, I will represent Mysore Sandal Soap for the next 3 years. And all promotional events is where I will be there. I will encourage. I will probably speak about it, so on and so forth. Now, again, you will notice that some of these endorsement contracts today very interestingly have a disparagement clause. I don't know if many of you know what this kind of a clause actually means. It's a very interesting clause that has been currently designed. If some of you are following contract law, you will notice that it was adopted by Vishal Sikka, and Infosys actually enforced this against him in the contract. It means that once the contract has closed, or once a contract has come to the end, you will not talk anything bad about that agency or that individual or that other contracting party. So you will not create any kind of disrepute, because generally when a contract ends, we get very frustrated. We generally, speak ill about our previous employer or previous contracting party. We may go public about it. So some of these things are actually now included in the contract. You will notice. So, while the contract has ended, there are certain clauses in the contract and the obligation of the same that continue even after the contract. So the contract might have been closed against Mysore Sandal, but you are not supposed to speak anything bad about this company or your experience about this company in any form or any manner is what such a clause can actually control you to do. So we say that in contract, you will notice that there are some clauses that are survival clauses. They survive even after the contract is expired. Right? So that is the kind of creative technique that contract lawyers are adopting. And it is actually interesting because it creates a new challenge. Again, the validity, enforceability, fairness, arbitrariness of such contracts probably have to be tested, right, from time to time. So endorsement contract is also something that is very, very interesting and challenging. But again, you will notice most endorsers do not want the player to go to the court. Why? Once it goes to the court, it becomes a public document, it becomes a public dispute, everybody can report, understand, and probably use it in a presentation like this. So what they do? They usually have an arbitration clause. Now, advantage of arbitration is, biggest advantage is confidentiality, right? The dispute does not go public, journalists don't write about it, and researchers like me probably don't get access to it. But nevertheless, I think even arbitration is one form of dispute resolution. It's an effective form. Nevertheless, these are some challenges that go by. Quickly going to issues like overseas players, right? Now in India, interestingly in football, you notice that there are a lot of overseas players that are coming in, and they also sign contracts. Now, while you say in national contracts, you do not have a choice of law, right? The law of the land will apply to contracts, right? That's what we say. Indian contract law applies to the territory in India, right? So when national parties are engaging in contract, probably, please note, you do not have a choice of law, right? The choice of law inevitably is the Indian law. But as soon as it's an international contract, what is an international contract? Where one of the parties is not an Indian citizen. That is one of the definitions of what an international contract is, but it's not the only definition, as it were. So when an overseas player, right, he may be from the African continent, from the European continent, say in IPL, you have overseas players from England, Australia, South Africa. Now, they want to engage in a contract with an Indian franchisee, right, in India, for a game either to be played in India or maybe to be played partially in Dubai. For example, IPL is going to UAE partially right now. So the place where the game is held is not important. But you are entering into a contract with an Indian and you're an overseas player. Can you have a choice of law, right? This is kind of a bargain. You will notice that no Indian franchisee wants anything other than Indian law, because they only know Indian law. They can understand Indian law. Their lawyers are well versed here. The courts probably will come to the rescue. But from a player's perspective, friends, look, if I'm a South African, the Indian law will be disadvantageous to me. The Indian arbitration could be disadvantageous to me. The Indian place would be disadvantageous. Why? Because if there is a dispute, I have to travel to India. I have to hire an Indian lawyer. I have to be in India. Probably I have to depose in India. So these sometimes can be quite interesting, quite challenging. And have choice of law clauses been incorporated in sports contract? The answer is absolutely yes. You see this, and the multiple challenges are not so much in India, friends, but the challenges that arise in EU or in the US are actually challenges that can be mind-blown. Because in the US, you will notice that the choice of law is actually a very confusing clause, right? And it has created a lot of confusion in sports law, as it were. But this is something that I thought I should also highlight, because some of these players, please note, can be less than 18 years of age, right? You notice that players generally, shine. For example, when Wayne Rooney's case came up before the UK court, he was just 16 years of age, right? So he was a minor, and the issue of minor in contract was also discussed in the Wayne Rooney's case. obviously it is better to have, some kind of precaution with guardians and others being attached to the contract. But nevertheless, the court always will have a favorable view to the player. The court will come to the rescue of the player for the simple reason is because he is the disadvantaged party. Right? So the contract will be read in his favor sometimes, and these can be interesting challenges that can arise as well. Quickly, friends, if I have to close in the last 2 slides, I will just raise one of the most interesting challenges that we face today in deciding contractual matters. Friends, sports contract, as it were, and sports challenges, as it were, are not simple. They're not pure contractual always, because sports contract and discipline are something that are interrelated. And when you talk about disciplinary issues in sports, please note, on the ground of disciplinary issue, it's nothing to do with the breach of contract. It's nothing to do that I'm not willing to play or I'm not willing to start a game. Nothing to do with that. So it's not breach in the contractual sense, but disciplinary issues actually result in contractual termination. Right? You will notice that in a sports contract, there are some very interesting clauses. One of them is called the morality clause. But nevertheless, let me explain some of these clauses. For example, I have a contract with BCCI, but I actually engage myself in a narcotic substance, right? In a drug abuse or something like that. And I don't pass some kind of test that is required mandatory before a game. Can my contract be terminated if I don't pass a particular kind of test, right? Or say sexual harassment in sports. Friends, remember, it's nothing core to sports. It's nothing in terms of whether I have done my job as a cricketer or as a player or as a basketball coach. My job I'm very good at, I'm very perfected with that. But there are allied disciplinary issues which can be challenging, to which probably the board or the franchisee may terminate your contract. They may actually result in taking an action against contract. So you will notice that when it comes to disciplinary matters, these have been challenged in the court. And obviously, the challenge is whether disciplinary action against me is justified, whether a proper inquiry was conducted, whether there is adequate evidence against me, and whether the disciplinary action is justified in terms of, say, 5-year ban, 10-year ban. All of these have gone to the court. Obviously, this is in public domain right now. Right? The court may probably say 10 years is good enough, let us reverse it, lack of evidence, circumstantial evidence, so on and so forth. So I think disciplinary matters have always resulted in disputes. However, the interesting issue that you have to note is how it impacts the contract, right? So should it impact the contract? Obviously, everybody will say, yes, it should. But please note, once it impacts the contract, it is not a pure contractual breach, right? So a pure contractual breach is in terms of, say, what I have agreed to perform in the contract and whether that performance has resulted in some kind of a loss, right? And remember, that loss is what we call as damages. And let me tell you, when you take disciplinary issue, what is the damage to the board? Is it damage of reputation? Or is it damage otherwise? And can that damage then be recovered from the player? So these are current issues. A lot of them have been discussed. There is a lot of writing on the same, both in the West and in India. But it's an interesting mix, as you see. And you will notice that sexual harassment in sports, unfortunately, is now coming to kind of public discussion. And a lot of people are speaking about it, speaking against it, and they're requesting for strict action, as it were. But at the same time, if you look at the arguments on the other side or the writings on the other side, they're saying, why should it really affect my game? And why should my game suffer? And remember, it's not about just the game suffering. Probably the player's livelihood also suffers, right? So a player, has no other means of livelihood except playing the game. And should disciplinary matters really affect his livelihood is something that one will have to probably pursue from a public policy dimension. Finally, friends, if I have to close, I will close on a very interesting side of saying, do players also need to know about contracts on their personal disputes? I don't know if you know about what personal disputes I'm speaking about. So far, I've spoken about players and their professional contracts. Right? What are professional contracts? The contract is with the club, with the board. What is their professional contract? Maybe with an agent. What is their professional contract? It is for an endorsement, and so on and so forth. But unfortunately, some of these celebrity players also enter into a personal contract. What is a personal contract? It can be something like a prenuptial agreement. Obviously, before you marry, you want things to be settled down. You get into what is a prenuptial agreement. Prenuptial agreement, friends, many of us think it's not there in India, but let me assure you that it is there in India. It's working. It's kicking in. Why do you need a prenup? There are multiple reasons. Probably, I want to protect my property. I don't want to share it in an alumni later on. I want to know who will take care of kids. I want to know whether I'll be inheriting to the assets of my husband, so on and so forth. So I think everybody wants to have clarity. And what is a prenuptial agreement, friends? It's an anticipation of kind of a breakdown of marriage. And does it happen? It does happen. We have recently seen Bill Gates, unfortunately, getting into a divorce. We have seen the Amazon boss, Jeff Bezos, also getting into a divorce. So rich people get divorced. I think poor people also get, let's not say rich or poor, but I think a prenuptial agreement is a reality. And do you actually negotiate a prenuptial agreement? Do you actually realize that this can have huge implication on future, as it were? And I think some of these players, unfortunately, have got into their disputes in their personal space as well. And obviously, where there are contracts, there ought to be disputes, and where there are disputes, there ought to be opportunity for lawyers. So disputes are good news for all of us, nothing wrong about it. But I believe that there mechanisms in which contractual disputes can be avoided. There is no foolproof solution to that. But nevertheless, if you draft it adequately well, if you understand it, look at its implication, I'm sure some of these disputes at least can be reduced to the extent of magnitude that it creates in the public space. Finally, friends, if I have to close my presentation, I have to say this, that players need support in compliance of law. They need support in contractual negotiation. And today you will notice that players are able to do the same by creating some kind of a cooperative of players. Now, it's not exactly creating unions, but we know that players need some kind of support to see what they're agreeing to, what they're signing to, what they say, yes, this is a contract. The contract ought to be at least fair. And hence, you will notice that in India, right now, as we speak, the fairness of contract is also about fairness of payment. One of the issues on contract sports and equity, as it were, friends, is you will notice that take the BCCI for that matter, equal pay for equal work is not applied by BCCI. What do I mean by equal pay for equal work? The men get paid more than what the women cricket team does. Obviously, you cannot compare these two. It's there in Wimbledon as well. The prize money for men and prize money for women are different. However, there is always a growing need for bringing in some kind of parity of pay, because most contracts then look at that kind of pay structure as well. Pay disputes in sports contract is also very, very critical matter. Very often than not, the board, the association, and the franchisee withhold payment. They delay this payment. They try to, arm twist the player when it comes to those payment terms and conditions, right? So fairness of pay, fairness of clauses and terms is equally important. And I think India has to probably bring in some element of public policy discussion even over there. And that is where I think some element of sports law will develop. To conclude, I would say, what is the need of the hour? The need of the hour, friends, is that our sports requires transparency and accountability. And if you look at how transparency and accountability comes into place, you will notice that we look at the application of the right to information law to some of these sports associations and sports bodies. Now, do some of these sports association and bodies come under the RTI? They do, but does BCCI come under the Right to Information Act? I don't know. Should BCCI also look at transparency and accountability of the system thanks to the Supreme Court's direction? Maybe yes. I think it's time that sports becomes more transparent, more accountable for the betterment of society, betterment of the game, and betterment of all stakeholders, as it were, in this game. Thank you very much.
Thank you, Dr. Sairam Bhatt. I beg apologies to disagree with you that this presentation was just an eye-opener. It certainly was filling. It was a mind-opener, substantial enough to arouse the curiosity of any knowledge seeker and equally of fans of sports. We thank you for dealing with matters in relation to several contracts relating to sports and players, like the organizers and fans, players and agents, franchisee and boards, and for also throwing light on the choice of laws applicable to players, professional contracts and personal contracts, and issues and disputes relating to them that could arise in their relationship with others. Thank you so much. We now move on to the next presentation, and I request I request Advocate Rohit Kamath to take over.
Okay, I'm sorry.
Advocate Rohit Kamath.
Yeah, Sonali, Rohit's presentation and mine have been merged together, so he will not be speaking separately on this. So don't worry. Please move on to the next presentation.
Okay, sir. Okay. So let's go on to the next presentation. Countries worldwide are turning towards alternative mechanisms for dispute redressal and resolutions in areas of sports. Arbitration is gaining immense importance owing to its advantages. The mechanisms provide effective and speedy redressal without compromising on the confidentiality and the privacy of the parties to dispute, while also safeguarding the interests of sportspersons. The guest speaker, Professor Dr. Amrish Kumar, will enlighten us on the topic, need for Indian Sports Arbitration Tribunal, similar to the Court of Arbitration for resolution of sports disputes in India. And to introduce the speaker, may I call upon Mr. Sriharsh Inavali, Assistant Professor and Head of the Department, to do the honors.
Thank you, Ms. Sonali.
Over to you, Sriharsh Inavali.
Thank you, Ms. Sonali. Respected chief guest, resource persons, principal, esteemed colleagues, and the participants. It's my pleasure to introduce a great personality in the field of sports law, Professor Dr. Amrish Kumar, the Director of Amrish and Amrish Law Associates, LLP, New Delhi. Professor Dr. Amrish Kumar, born on 29th April 1962, and completed his bachelor's and master's degree in physical education from Lakshmi Bai National Institute of Physical Education, Jivaji University, Gwalior. Sir also obtained PhD in physical education on a study of dermatographics in sports under the supervision of Dr. N.N. Laha, Professor of Medicine, JR Medical College, Gwalior, and Dr. S.T. Mala, Reader of Physical Education, Gwalior, from the same institute, that is Lakshmi Bai National Institute of Physical Education. Coming to the academic achievements of Dr. Amrish Kumar. Dr. Amrish Kumar worked as a lecturer, associate professor at Lakshmi Bai National College of Physical Education and Lakshmi Bai National Institute of Physical Education, deemed university, during the period of 1984 to 1995, 1999 to 2004. Sir was sports advisor and advisor to Sushri Uma Bharati, then the Minister of Youth Affairs and Sports, Government of India, from 2002 to 2004. Sir worked as professor, principal, and served as in various capacities in several education and physical education colleges during the period 2004-2014. Sir was Dean, Faculty of Education and Psychology and Director of Sports, Mewar University, Chhattisgarh, during the period of 2018 to 2020. He is also Dean of Academic and Faculty Affairs, Ekalavya University, Damo, Madhya Pradesh. Coming to the writing work of Dr. Amaresh Kumar. He has authored several books. To mention few, wrote forward of a book, CAS and Football, a landmark cases series. ASSER International Sports Law Series, edited by Alexander Wild. Sir also authored 3 books on sports law in India, Knowledge Series, and it got commendation by Honorable Chief Justice of India and Union Law Minister on the occasion of International Law Day. He's also authored 16 textbooks on sports, physical education, Olympic studies, yoga during the period of 2005 to 2012. Coming to the sir's experience in the bar, he enrolled as an advocate in the year 2000 in the year 1995 and joined the office of Sri Arun Kumar Mishra, who became judge of the Supreme Court later. Enrolled as member of the Supreme Court Bar Association in the year 1996, joined the chamber of late Sri R.K. Jain, senior advocate of the Supreme Court. Joined office of Sri Manoj Goyal, advocate as associate partner, that is during the period of 2006 to 2012. Formed an outsourcing law firm, counsel and advocate in 2010. From 2004 till date, sir has different positions as advisor to various educational institutions, and he is the educational and legal advisor on retainership basis and legal advisor for establishment of StarX University, education and legal advisor for StarX International School, StarX Sports Academy, StarX Institute of Education, Gujanwala Gurukul Trust Society, Bapudam Education Society, StarX Foundation, company matters at New Delhi and Gurugram. It's also legal advisor, member IQAC Arbitration Committee and trainer Dope Education, that is from 2010 to 2018. He formed a law firm, Amarish and Amarish Law Associates, in the year 2018 and till date. Coming to the international experiences of the chief guest, we can say that he was honorary visiting professorship and research fellow for international and European sports law at ASSER International Sports Law Center, TMC SR Institute, The Hague and Netherlands. He is member of the Board of Advisory, the International Sports Law Journal. He is a member of Financial Planning and Sports Legislation Committee of International Association of Sports Law, Athens, Greece. He is a practicing as member of International Sports Lawyers Association Zurich, Court of Arbitration of Sports for Sports, Switzerland. He elected the first and founder General Secretary of Asian Council for Arbitration for Sports, Seoul, South Korea. Invited as keynote speaker in the World Congress in International Association of Sports Law, Athens, Greece. Sir, practicing constitutional writ and appellate side, drafting, legal research and briefing senior counsels in the High Courts and Supreme Court of India, appearing independently in the Central Administrative Tribunal, handled various sports-related cases in Supreme Court of India, Delhi High Court. So, I don't think we can get a better person than Professor Dr. Amaresh Kumar to be a chief guest of today's webinar. Thank you, sir. Thank you for joining with us. I heartily welcome you to this particular webinar. Thank you.
Thank you very much.
Thank you, Inauguration, for doing the honors. Before Dr. Ambarish Kumar proceeds, I would like to place on record my apologies for having missed out to appreciate the contribution of Advocate Rohit Kamath. Thank you, sir, for your time and for your valuable contribution in the presentation that was covered by Dr. Sairam Bhatt. May I now request Dr. Ambarish Kumar to take over the platform.
Thank you, Sonali.
Thank you, sir.
I'm highly thankful to your chairperson, Mr. Nitil Punli Nikar, Principal Dr. Saba De Silva, then your President of the Alumni Association, Prasad Nayak, Dr. Manoj Hedge, to give me an opportunity to speak as a guest speaker on this very wonderful seminar or webinar, I can say, you can say, on sports law. In fact, the sports law, can you please play my slides, or I shall share it myself?
So, sir, do you want us to share the screen?
It has been already been shared.
Yes, sir, it has already been shared. It's visible.
Okay, thank you very much. So, my topic today is a bit different what our eminent speakers have told or spoken earlier. Dr. Sai Ram has very much enumerated about the contract law in sports, and that is very much essential nowadays. But most of the speakers have concentrated their speech to the cricket only. But the sports law is not only limited to the cricket or only to the contract law. It is very complicated, complex subjects, which includes so many subjects in sports law. But I will not be speaking. I will share myself. Please let it be from my side. I'm already sharing my slides.
Yes, sir, as you wish.
Thank you very much, Sonali. So, speaking about the sports law, in India, the question came from Dr. Sai Ram, whether there is really a sports law in India. Of course, Professor, sports law is there in India, but it is being not practicing by our legal fraternity or by the athletes, by the sports persons. There are two things which is being there. IUA in their constitution, on the recommendation or on the, you can say, threat of the IOC, has included a sports arbitration clause, a sports arbitration commission in their constitution, and that is there. Then in 2013, Government of India has enacted a National Sports Development Code. In that also, in the name of sports ombudsman, the sports arbitration or sports law has been included. And to my surprise, when I went to the Lausanne to attend the IQAC, International Court for Sports Arbitration workshop, I was surprised to note that sports law or sports arbitration tribunal, which is World Sports Law Tribunal, has been enacted in very first time in India in the year 1986. During the 86th International IOC meeting in New Delhi. But surprising to us that only in India we are not following this sports law or sports arbitration. So coming to my main topic, that is, I think the administrator is operating the slide, so please let me operate myself. I am sharing it so that I can speak slide by slide.
Okay, sir. Okay, no issue.
So, as my topic was formation of Indian Sports Law Tribunal, same as to the International Court for Sports Arbitration, or CAS. So, the first introduction about the CAS is that I think my slide is being not shared. Have you stopped sharing it from your side?
Sir, I think your slides are not visible to us, so it would be in the interest of things that our administrator here does the needful.
Thank you very much. Then
Thank you.
slowly.
Yeah,
please
yeah.
do it.
So you could give us a command and we could change the slides accordingly.
Thank you very much.
Yeah.
The second slide first. The second slide is the third one, the previous one. Yes, thank you. Let me give you the brief introduction about the International Court for Sports Arbitration or Arbitration for Sports. You all might be knowing about it is located at Lausanne, Switzerland, and the present president is Mr. John Coates, secretary is Matthew Reeve. It has got decentralized office in Sydney, New York, and Shanghai, China. It was very bad luck on behalf of our country that it was banned. IOA was banned by the IOC for not including the arbitration clause in the constitution. Otherwise, it was coming to the Delhi. But China is so smart. They have constituted and they have got the decentralized office in Shanghai, China. And then there is an ad hoc court wherever the Olympic Games are being organized, wherever any World Games are being organized or international tournaments are being organized. On the request of the organizing committee, the CAS established an ad hoc court, and it is surprised to note that these ad hoc courts have to decide the sports disputes within 24 hours. But next slide. Now coming to the sporting jurisdictions. In most of the countries and especially in India, all the sports disputes till date are being decided or adjudicated by the court of law, either under civil law, constitutional law, or contract law, by high courts, by Supreme Courts. But sports jurisdiction says that sports today is at international level. So it has to be decided as per the international law and legal order internationally, the lex sportiva. The nomenclature has been given the lex sportiva. So universal sports. The arbitration clause or the sports law has to be as per the particular sports law. The court of the land, civil laws, Constitution of India, or whosoever the nation is that, cannot decide the sports law as per their own law. And Court of Arbitration for Sports is considerable power within the sporting legal orders. Whatever the sporting legal orders are there, under the Rule 59 of the International Olympic Charter, all the sports disputes shall be decided by the Court of Sports, by the Arbitration Court of Sports Law, that is CAS. Then definition of the jurisdiction is that it is context to the legal order. Then the organs competent for dispensing jurisdiction in relation to the sporting activities of the context of the rules as per the lex sportiva. The International Olympic Committee has their own rules. The International Sport Federation has their own rules, and all the sports disputes has to be adjudicated under these laws. You might have, in the last slides you will see, you might be knowing about the case of the Srishant, a cricket player. He was banned by the BCCI for match fixing, passed back 4-5 years or even more than that. I was the first person who spoke on the TV interview that Srishant has done nothing wrong as per the sports law, and he will be freed spot free. He will not be charged by anything, though it took long time from one court to another, from up to Supreme Court, and then Supreme Court in the last year had relieved him from all the charges by the BCCI. Only the punishment will be decided by the BCCI Disciplinary Committee. Next slide, please. as the lawyers, as the law students, and as our eminent listener might be knowing, that arbitration jurisdiction or arbitration is a mechanism by which any dispute is being resolved by party. It has to be agreed before that we will go by the arbitration clause, and the third party with the common acceptance or common agreement with both the parties choose a arbitrator, and then arbitration has been decided. The similar way in sports, though the third party is to be chosen by or be selected by the sports person or the disputed persons from amongst the panel of the arbitrator or mediation under empaneled by the CAS. So that is the arbitration which has to be conducted in the sports arbitration in according to the rules of the CAS. Next slide, please. Now come to arbitration in sports. A sports arbitration is an interpretation of the rules of the international sports and the IOC rules, IOC charter, you can say. No national law or criminal law or civil law of any land can interfere in this sports arbitration disputes. The arbitral panel and the statutes of the international sports federations are there, and it has to be decided according to that. A sports federation arbitration tribunal has to be decided by the CAS, which is known as the Court for Arbitration for Sports, or TAS, it is a French word which is known as the TAS. Then as national sports law or provisions of the rules of national federations. In any different nations, or India, you can say, it has to be decided as per the national sports law federation, national sports federations or national federations. Then the CAS, the nature of sporting arbitration is mandatory arbitration. So all the sports body, international sports body, has included the provisions of the sports arbitration in their constitution, and that has to be followed by all the national sports federations. So slowly, if you examine the constitution of the national sports federations, athletics, badminton, wrestling, they all have included the jurisdictions of the arbitration tribunal or arbitration procedure in their sports dispute redressal. Even the Supreme Court of India, in the case of V.C. Shukla versus Adityan or K. Murugan, has spoken that there is a very good clause in IOA constitution, that is arbitration clause, but people are not adhering, or people are not taking the course of this clause, and the courts are unnecessarily burdened. Nowadays, several court cases are pending in various different high courts, various Supreme Court. And in some of the cases, the people are approaching just to spoil the career of the sports person. So that is the arbitration procedure of the sports, and all the sports disputes has to be decided under the process of the arbitration, under the provisions of the Rule 59 of Olympic Charter. And for that purpose, in 2010, because it was not there in the IOA provisions, the International Olympic Committee has banned the Indian Olympic Association for that purpose. Next. The sports law excludes what? Because when the court, the disputes of the sports goes to the court adjudicate the disputes as per the land of the law. But the sports law excludes the following: implementation of sports law as international lex sportiva. All the sports law has to be adjudicated as per the lex sportiva. The provisions of each national sports law and rules of the relevant federations may contain a different interpretation and implementation. Whatever the provisions by national sports federations or bodies has been implemented, that has to be followed. The court cannot adjudicate the same things as per their own land law of the lands. Like in some of the speech, the contract law has been elaborated, Of course, the Indian contract law is there, but the sports contract law has been enumerated or enlisted by the different national sports federations and sports in their constitution, and that has to be implemented. The national contract law, Indian contract law cannot be included in the sports law disputes or sport disputes. Tactics of International Federation of an IOC, whatever the tactics, whatever the IOC has been stated, that has to be implemented, and no other law from the land or from that nation has to be included in the sports law. Then it should be uniform practices, international and national level. Whether it is for X, for Y, for Srishant, for Sri, you can say BCCI previous president, the uniform practices has to be adopted. An obligation of the competent organization or Federation of India to bring the regulatory system under national law into line with the provisions of the rules of international federations, WADA, and national anti-doping agencies. Nowadays, doping cases are also being increasingly large. That is a NADA, National Anti-Doping Agencies, which is roping so many athletes, so many players under the doping clause. They say it is dope positive. But the thing is that one of the cases I had appeared for one of the athletes, that is a IQAC. He was roped for the dope positive. But when it was examined, then he had taken no medicines, no substances, only he has taken the liver. Liver is the food which is being consumed by the athletes, or the meat food, and from that he is he has enhanced the performance, but the NADA has roped him the dope positive case. The appellate authority of the NADA has refused. Then I went to the High Court, and then on the basis of that under the laboratory test, there are only 2 assessors approved by the WADA in India, and the dope test laboratory of India has not got the test assessed by those 2 assessors. On this basis, the High Court of India, the Delhi High Court has relieved that person, and that person has been freed by the High Court by the dope test laboratory charges of dope positive. Next slide. You might be knowing the case of the I came to the history of the creation of the International Olympic Court of Arbitration. The first Court of Arbitration was enacted in the Delhi in 86 annual session of IOC in 1986, and it has been created by the International Olympic Committee in 1984, but the enactment was passed in India when Justice R.S. Pathak was the judge of the International Court. Then reason for creation, because there are a lot of increase in the international sports related disputes, and the arbitral institutions specialized in setting international disputes was not doing the things as per the sports law, as per the law of the sports. So this task has been created by International Olympic Committee. Next slide, please. We all know about the case of the Duti Chand. Duti Chand was found or roped by the IAAF, International Amateur Athletic Federations, that she has got the male syndromes or male hormones in their body, and that's why her medals was roped down. So if she would have gone in the Indian court or somewhere different court, civil law or other law, she might have not got the justice so fast. The Government of India and the chairperson of the KITS, Kalinga University, have helped them, and she has gone to the CAS, and within 45 days, within few days, the identity order was passed and she was allowed to participate in all the sports events, and now she has been relieved of all the charges of her male hormones, which was blamed by IAF, and her sporting medals was withdrawn for the Glasgow 14 Commonwealth Games. The similar is you might be knowing about the Srishant. Next slide, please. Yes, Srishant is a very good cricketer. He was a very good cricketer. In the legal IPL match, he was robbed for the match fixings. One of the very eminent lawyer, or you can say judge, he had imposed the ban, and on his recommendation, he has recommended the ban on him, and on his recommendation, the BCCI has banned him for the life playing from the cricket. He went to the Supreme Court, and from the Supreme Court, last year his life ban has been invoked, and he has been asked that there is no life ban. The ban imposed by the BCCI was wrong. Next slide. In conclusion, what I will say that though there is a Sports Arbitration Commission in IOA, Sports Ombudsman in National Sports Development Code, as well as the first in statutes of the International Court for Sports Arbitration was enacted in India, but still there is no sports arbitration tribunal in India to decide or to resolve the disputes of the Indian players, and result being that they have to go to the Indian courts, either the High Courts or the Supreme Court, and the Indian courts are taking how much lengthy times to decide any disputes. A short example I will give about the election disputes of the IQAC. There was a dispute, and some of the losing party has filed a writ petition before the High Court. I was the advocate for the IQAC. I requested the Honorable Lordship, Honorable Judges, that this case is not to be adjudicated by the High Court. This comes under the Arbitration Tribunal. There is a law in arbitration. There is a International Court for Sports Arbitration. There is a IUA arbitration clause, and the writ petitioners might have invoked the wrong jurisdiction before High Court. So initially, the Honorable Judges was annoyed. They told how you can challenge our jurisdiction. What happened? Then I told, I am not challenging the jurisdiction of your Lordship, but there are provisions. Sports is a different part, and under the provision of the IOC Rule 59, it has to be adjudicated by the Sports Arbitration Tribunal. Then they asked me to show the things. When I showed them, when I presented the rules of the Olympic Charter, Rule 59, and the arbitration clause of IOA, the judges was very much happy. And they told, they immediately dismissed the writ petition of the petitioner and told that why people are coming to the High Court, why people are burdening the High Court for these type of sport disputes, when there are so much very good provisions in the sports under the International Olympic Committee, Olympic Charter, or IOA Arbitration Commission. They should go to there. So what I feel as an advocate, or my colleague advocate, does not come frankly before the court that there is a sports arbitration tribunal, there is a sports jurisdiction which cannot be decided by the Honorable High Court or Honorable Supreme Court, and they should either refer the case to the Arbitration Commission of the IOA, or they should form the districts. But the thing is that we don't have any independent sports arbitration tribunal or court in India, and that's why we require a very good, or it required to be enacted a sports arbitration tribunal in India. Next slide. This is a book which I wrote, a sports dispute redressal in India, and I have already enumerated what I have spoken, that IOA Sports Arbitration Commission, Ombudsman Commission of the Government of India. But the only disputes which I feel I'm fighting for these things from last 2010, when our president, Mr. Prahlad Singh Patel, who is the Minister for the Culture and Tourism in present government, he is the president of this Sports Law India, that sports arbitration tribunal should be constituted in India. There were so many seminars which was conducted, recommendation was there. Even the sports minister, Mr. Sarbanand Sonowal, when he was the sports minister, he came, he agreed. But the thing is that as per the IOC charter, the arbitrator should be an independent person. They should not hold any position in any way in any disputed party, either maybe IOA or maybe National Sport Federations or even the Government of India. But there is a fight between the Government of India, between the IOA, that we should appoint our own arbitrator. For some time, they have appointed Justice A.R. Lakshmanan, retired Justice of Supreme Court of India. Honorable Justice is no more now. But the thing is that when I discussed with him, he told Amresh, I am the chairperson of IOA Arbitration Commission, but till date, I have not been referred any case by the IOA. So that is a very crucial part, or that is a very apathetic part of our Indian government, of our sport federations, of our IOA, of our National Olympic Committee. As Professor Sainam has stated, is there any sports law in India? Yes. As per you, presently there is no sports law in India, but it is not in practice. As per me, there is a sports law in India, but it has to be ruled, it has to be practiced. So next slide. You can click here two, three times, a small 2 or 3 minutes video is there where the president of Sports Law India is speaking something about the Sports Arbitration Tribunal, which we have conducted. Please click it to.
So it is not getting played.
Times.
Dr. Amrish Kumar, it is not getting played. The video is not getting played.
Okay. So I would like to share my own video if it is being there. It is only 2-3 minutes. Have I time? Can I show it?
Yes, sir. Sure. You can continue.
Thank you,
yes, sir.
Thank you, please. Is it being visible?
Still not, sir. We are waiting for it.
Can you please stop sharing from your end so that I can run it from here?
We have stopped sharing from our end, sir. We have disabled it.
The video is not being visible.
Not yet, sir.
Sonali, I think Dr. Amrish has logged himself out.
Yeah, I just noticed. I think we'll wait for quite a little time so that he rejoins.
We'll just wait for a time. Otherwise, we'll buy it. He's logged.
He's back.
Yeah. Dr. Amrish, you are not audible.
I'm sorry, it was disconnected. I don't know somehow. The presentation, the video was operating and it was disconnected.
Some technical issue maybe. Okay, you can go ahead with it.
So you could go ahead with your presentation. So would you like us to share the presentation?
Yes, please. Yes, please.
So your screen is being shared. I think you are having a difficulty at your end. Do we go ahead with screen sharing, sir?
Please, you share my screen, please. Thank you. Sorry.
Yes, sir. Yes, sir. Surely we'll do. Kindly hold on, sir.
I'm holding, please.
Is it visible?
Okay. Is it visible?
Yes.
Thank you.
Thank you, sir.
Next slide, please. Can you play the video in this? Is it possible?
So there is some difficulty in playing the videos.
Okay, sorry.
Yes, sir. They're not getting played.
Then I will send these videos to all the participants on their email, which you have sent, because these are the very informative things. The president of the Sports Law India is speaking about the sports law, and he is making all the efforts to constitute the sports arbitration tribunal in India. And second slide is in what way your law college, that is.
1 second. So do you want us to move to the next slide?
This is the last slide. This last slide. So I'm sorry that these two videos were very important. I don't know how it is not being playing. I will send these videos to all the participants who have on that email which you have shared with me.
Thank you, sir.
And then it is very important that some sports arbitration or some court of sports arbitration, if your college, that is the GR Kare College, can start some course at their, because Principal Dr. Saba is very eminent professor with different subjects. He has come and he has started his law practicing, and then he has become the professor in law and principal. So it will be very good if you join with Sports Law India and start some courses on the arbitration tribunal. If you can start at your law college.
Certainly, sir. Certainly.
The Government of India to be the part of that. Thank you very much.
Certainly. Thank you so much.
Thank you, sir. We certainly would be happy to receive your videos. In recent times, ADR worldwide has been gaining mileage over litigation in several areas, and as we have seen, sports is not an exception. We thank Dr. Amrish Kumar for highlighting the importance of dispute resolution mechanisms in sports, as well as by substantiating the presentation by citing various examples. As we see, arbitration has been instrumental in effectively resolving disciplinary disputes in sports, and this supports the need for Indian Sports Arbitration Tribunal. I thank you, sir, for this wonderful presentation.
Thank you very much.
As we reach close to the concluding part of this national webinar on sports law, I once again, on my personal behalf, express deep appreciation and thanksgiving to each of the speakers here. Each of you were impressive, and this intellectual exercise has undoubtedly left us enriched. We will certainly leave with a very rich experience and remain indebted to you. May I now ask the audience whether they have any questions?
Sonali,
anybody? Yes, Shruti. Yes, Dr. Shruti.
Yeah. I wanted to ask a question. It is open for all the resource persons actually. That is there a need for dedicated sports legislation in India?
Shruti, whom is the question posed to? Do you have any specific speaker in mind?
I would like Dr. Zairam, but if you could answer this, that is there a need for dedicated sports legislation in India?
Hello, Ms. Shruti. I'm Rohit Kamath here. Sairam sir has asked me to take over this meeting because he has another engagement.
Yes.
So basically, I'd like to answer, and this was what the arrangement that we had, that I would join in for the question and answer session. Like say, for instance, when we speak about having a sports legislation, if you're going to look at it, because each sport has its own set of rules and regulations. Now, be it cricket, be it boxing, be it the Olympics, they have their own separate legislative or the rules making mechanism that they have, which is commonly called as lex ludica. And given that sports law in per se, if you're going to have it as by means of a legislation, it matters as to what areas of sports are you going to govern by this legislation. Because if you look at the aspect of cricket is more governed by the BCCI, which is a non-governmental organization by itself. So which is this aspect that you want to regulate by legislation? That is something that probably, would garner the aspect accordingly.
Shruti?
Yes, madam.
Yeah, the other thing which to add to what has been said, please remember one thing, that as of now, under Justice Mudgal's chairmanship, 2 bills are pending. They're still pending. One on corrupt practices, match fixing and all. Okay. The other is again with respect to accountability within sport, right? So, and as Dr. Kumar was saying, there is also this attempt to set up a domestic sports arbitration tribunal, which India lacks. So for that also, you would like to have a legislation which applies across the board, irrespective of which sports. So there are certain aspects on which you can have a legislation that will crisscross irrespective of the kind of sports you're talking about. Apart, like, sexual harassment. So if you look at the National Sports Code, it has got on, say, election within the National Federation, how the election ought to be conducted. Then with respect to sexual harassment complaints. So all these issues, yes, you can have a singular legislation. But as was pointed out by Mr. Kamath, you have to understand that, yeah, there cannot be a micromanagement of individual sports because, as Dr. Kumar was saying, you cannot override ultimately. Remember, the National Sports Code also starts with the disclaimer that it is within the boundaries that the International Olympic Committee has laid down. So if you want to be a participant within the international community, you cannot superimpose your own ideology. Your legislation will have to be within the 4 corners that has been imposed on us as sports persons or administrators. Okay?
Yes, thank you so much, ma'am.
Thank you, Dr. Lovely Dasgupta, as well as Advocate Rohit Kamath for the responses. May I have some more questions?
Yes, ma'am, I have a question.
I'm sorry.
Whom is it addressed to?
It's a general question that is raised, that if a player has a contract with the club for a certain amount of salary, what is the outcome of such a contract? Now, I can give you an example of Deccan Charges, which was actually a team which is now known as Sunrisers Hyderabad. Now, in this case, there was also an allegation that Deccan Charges had not paid in the salaries for most of its players, on account of which BCCI terminated their contract. Now, that was one particular aspect, you could look at to understand as to how, these regulatory bodies can have a control. But however, if you look at it, this matter was settled by means of an arbitration. And wherein the sole arbitrator decided in favor of Deccan charges and has given across that, BCCI is liable to pay a compensation for Deccan charges for wrongful termination of the contract. Yes, Satyavardhan. Sorry, I interrupted.
No, sir, it's okay, sir. It's all fine. Actually, my question is in context to, again, national sports federations in India. We have a lot of national sports federation. But when we talk about rules and regulation, like for example, the recent case of Sushil Kumar, in his SGFI, School Games Federation of India, there was a dispute about the national body election. I belong to a sports called Taekwondo. And in this sport, the dispute is from last 5-6 years. The court case is pending in Delhi, Honorable Delhi High Court. And the players are having a lot of, they're suffering with a lot of loss. Recently, we had Olympic trials as well. Sai couldn't send the team, despite after selecting them and after following the 14 days quarantine process and everything. So can't we have a law which can actually monitor all these things, like to resolve all this kind of dispute, or a basic necessity for all the state association or the district association as well? Because when there is a problem at national level, then a lot of groups forms, and because of those groups, we have a lot of 4 or 5 state level association, 4 or 5 district level association, which creates a confusion amongst players that where to go, where not to go. So do we have any law for such kind of situation?
May I speak on this question of Satyavardhan? Mr. Satyavardhan, I have also heard your Taekwondo cases going on the Delhi High Court. And as per the Supreme Court judgment, all the sports disputed where the IOA is the party has to be filed in Delhi High Court. No other high courts in India has the jurisdiction to hear any cases where the IOA is the party. Here, IOA is one of the party. The thing is that you have gone to the High Court. High Court will take its own course, its own procedure, and then it will be taking whatever time you are saying, and players are not going. If you might have approached the Arbitration Commission of the IOA, perhaps your case might have been decided very fast, and as per the mandate, it has to be decided within 48 days as per the International Court of Sports Arbitration. Or if you are not satisfied, you should have gone to the CAS. Like Jyoti Chand case, she would have gone somewhere here and there, then perhaps her life might have been spoiled and she could have not participated even a national athletic meet. So what I experienced from your cases, which I am a regular listener also sometimes because I am going to the High Court and listening it. The first and foremost thing is that your different association, national association, there are 2 national associations for Taekwondo. They are fighting each other. They are staking their own claims, and the same thing has been happened in one of the might be sports, this triathlon, where running, swimming, and cycling is combined. And one time, Mr. Rama, who was the president of the IOA previously, Ramachandran, and there was one vice president, Miss KV Singh, wife. They filed the cases in various high courts. And Ramachandran, being the tycoon of the Cement India, he filed different cases in different high courts. So what I did as an athlete supporter, I requested a few athletes of triathlon federations. They approached to the Supreme Court stating that we are the national player. Because of the disputes with the 2 factions, the team is not being sent to the international competitions, and we are the sufferer. So kindly constitute an arbitration tribunal or an arbitrator appointed by the Supreme Court who can conduct the elections, and whoever wins, they can run the show, and the athletes should not be suffered. The Supreme Court had immediately passed the order. You might check this orders in the Supreme Court cases also. I can give you the reference also. And then the election was conducted in the arbitration of the appointed by the Supreme Court, and of course Ramachandran wife won, and the sports is going on. The similar way is the judo also. So that is the things. Until and unless परेशान कौन है?
Player.
दूध किसको पीना है? अगर आपको परेशानी है, आप सामने नहीं आते तो ठीक है, वो तो पैसे वाले हैं, उनको तो प्रेसिडेंटशिप चाहिए, सेक्रेटरीशिप चाहिए. They are not bothered about the players. They are bothered about their own positions and the money behind the body which is being given by the government of India as a grants.
Right, sir.
So if you are a player, if you are a well-wisher, collect some national players who are probables, file a case, common case, in this only that we are the sufferer. You appoint any arbitrator, and nowadays in the case of this is Rahul Mehra.
Yes,
the High Court has appointed, conducted so many elections of so many federations, football federations, archery federations, and so many federations. So that is the thing, and that way you will get the relief from the Indian courts. Till date, the arbitration tribunal in India is not active, not in practice. That's the way.
Thank you so much, sir, for answering so beautifully and specifically. If you permit me, I want to add on something, one more query regarding this itself.
You asked from the Sonali.
Okay. So can I?
I think we would take some more questions from others, and then we would revert back.
I mean, it's just one-liner question. I mean, like yes or no.
Okay, whom is it addressed to?
Dr. Amresh can answer because he knows all these things.
Please keep it short. Please keep it short.
Yeah. Yes, ma'am, it is very short. So since the National Federation is dispute, IOA appointed India Taekwondo a national body federation, which is acting as a sole authority for India without even having any affiliated state association or district association. They are conducting too many online events and which people are not aware of. So is it fair?
Satyavardhan, according to me, sports cannot be played online. Live about this video games or some online games like PUBG and other things. Taekwondo, athletics, online, I think it is not be possible. So this is all unfair things, according to me. It should be on the ground. It should be on the mat. Though COVID-19 option is there, it cannot be done. But Government of India has issued some guidelines to conduct this sports tournament, and that should be according to that. And if you are saying IO has some committee, perhaps the president or the secretary of have chosen their own choice and they have appointed some committee. Then none of the players might have approached the IOA under the arbitration clause that you conduct the election or you constitute the committee of the sports person. Those who are not playing, but they are the Taekwondo players. The committee could have been constituted of those persons, because what I think, as a sports person, you may do not more than 50% corruption. But if you are not a sports person, 100% is being grabbed by the sai under the name of Khelo India, which I say it is a Khalo India. The Khelo India is being 24 crores rupee has been invested only for the branding. And in Khelo India University Games, I had been there. No technical person was there. No nothing was there. A company from the south, very well known to the Honorable Prime Minister, has been given the branding things, only play cards and something like that. And the players have conducted the games. So it is all more than, I don't want to say as on the open, it is a corruption from the Government of India side to even the IOA.
Thank you, sir. Thanks.
Thank you. There is a question from a student named Astrid, and I think since it is related to gender, Madam Lovely Dasgupta could respond to it. The question is, how significant is the role of sport in addressing awareness on gender inclusion in the society?
That's a good question, and I think the answer is that emphatic yes, because sports, is part of our existence. I mean, you cannot divorce the society and sports at all, right? So the fact that we are not able to divorce society from sports is also the reason why law has to intervene within sports. And that is the reason why we are discussing the various aspects of legal intervention in the field of sports, which has also led to a discipline, debatable it may be, but nonetheless a discipline called sports law, right? So definitely sports has the most important role. And the fact that due to the vociferous outbursts, or one can say the arguments being professed by all the female sports persons, that you are looking at a scenario where tournaments are forced to give equal prize money to both male and female athletes. It is also because of this movement that is taking place within the sport that now for the first time you will have a transgender athlete participating in the Tokyo Olympics. So I think sports definitely, and if there is a change in the approach of people within sports, because sports reflect the sentiment of the society. So the more progressive you become within sports, the more progressive you will always be within your societal practices, and definitely there will be gender parity and gender accommodation, definitely.
Thank you, Dr. Lovely Dasgupta. There is one more question from a student named Jitika Patekar. Jitika, whom would you like this question to be answered? Who would you like to answer this question?
Yeah, ma'am, I would like Ma'am Lovely to answer my question.
Okay. The question is, what is the impact of COVID-19 on the quality of sports, and what measures should be adopted to overcome it?
She wants me to answer this?
Yes, ma'am.
Okay. I think, Jitika, you've asked a very relevant question. Jitika, I think the answer, as I said, again, will be what we are witnessing within our society in this COVID-induced lockdown. That is the enormous increase in mental distress amongst people, and of course athletes are not outside the purview of that, but see, athletes are trying to keep up their practice, and now many of them are also getting a chance to participate in Tokyo Olympics. And in many parts, as you can see, the spectators are coming in. You've seen what happened in the French Open. You see what will happen in Wimbledon, and look at what is happening. So golf has resumed. So you are looking at sports resuming. Euro 2020, for example, is a big eye opener. So yes, sports is opening up. And the same measures that you advise to ordinary citizens or students, so the same measures you have to advise to the athletes as well. That the mental counseling, the mental health aspects needs to be taken care of. And of course, here federations have an important role to play. But I am not sure whether the federations are putting in that much effort, as Dr. Amresh Kumar, as Professor Amresh Kumar was himself pointing out, the kind of apathy that is there towards the sports persons in general, as far as the administrator within the federations are concerned. This is again a very, very individual initiative to approach the psychiatrist or the psychologist and get a mental health counselor. But as you will read through various literature, sports persons are trying to keep up with their activities and trying to make life as normal as possible. And considering that they are slowly returning to the field, I think that also has a very important role to play in the way they're going to handle their mental issues.
Adding to the lovely Dasgupta, if you are looking for the national level sports, of course, COVID-19 has affected that. But if you want to practice sports in general for your own health being and for your own prevention, I think if you are practicing sports, sweating yourself, the COVID-19 panic should not come to you. The sports person or the laborers who are sweating, the research has come from the WHO, World Health Organization, that those who are sweating, they are lesser prone to the COVID-19. COVID-19, according to me, is a general cold and cough, a bit vulnerable, a bit aggressive things, but it has not to be panicked. 60% death has caused due to the panicity. If a doctor told you that you are COVID prone, positive, you are getting afraid, and then If you go to the hospital, there are chances of getting the COVID-19 more. If you stay at the home, the chances of getting cured by the COVID-19 is more. So thing is that COVID-19 has nothing to do if you want to practice sports as your general life. In your general life, don't stop. Go for the running, go for the jogging, play sports, nothing will happen to you, according to me. And it has been practiced by me also. The COVID-19, though fatal thing has happened to whole of the world, but a sportsman, hardly 1 or 3 sports person has been reported affected by the COVID-19. That's my opinion.
Thank you, sir. Thank you, madam. I think on account of paucity of time, we will not take any more questions. Thank you, each and everyone.
Sonali, one more thing, just if you permit me, whatever has been asked by Shruti, that
yes, what?
Enactment of the sports legislation is must or not. As Rohit told, for the federations it cannot be, but at least for the development of the Indian sports, the sports legislation is a must. Different parliamentary advisory committee or parliamentarian has come up from the long past that there should be a sports legislation. As you might be knowing, there are different bodies to control the sports in India. First, start with Sports Ministry. And Ministry has constituted a body known as the Sports Authority of India. According to me, it is a Sports Anarchy of India. Then Indian Olympic Association. Then National Sports Federations. 4 bodies are there. If a player went to participate in the international tournament, loses, they start aspersing the things on each other. No, Sports Authority of India ने कुछ नहीं किया, Minister ने grant नहीं दिया, IOA ने कुछ नहीं किया, Federations ने कुछ नहीं किया. If anybody wins, oh, it is my head, they come to the collar. So there should be one body to control the sports in India. I have submitted the proposal to the then Sports Secretary, Mr. Injati Srinivas, stating several sports legislation of the different countries. China has got the sports legislation, Germany has the sports legislation, African countries have got the sports legislation. The thing is that how do you want to control the sports? It is only one subject. Medical sciences have their own legislation, law is having their own legislation. Only sports is the things which is not been legislated in India, and that's why we are suffering. The 94% non-sports persons are looking after the sports in the country. They are planning, they are making the drafts, and they are being done. You see the DGSI, a non-sports person. Secretary of Sports, non-sports person. All the sports, non-sports person are in the ministry. So there should be a legislation that at least a sports person, those who have been graduated in sports, physical education, they must be given the management of sports in India, and then I can say sports will develop in India. Otherwise, Indian sports will never develop. The effort has been taken. The Plas Singh Patel has asked the questions. Murli Manohar Doshi has stated that, okay, we will include the sports in UPSC examination. Sarvanan Sonowal has agreed to constitute an Indian Sports Services consisted of the sports person. The thing that it has not been done, it will never be done. And if you don't do it, then sports India will never be developed. That's my submission. Thank you.
Thank you, madam. Thank you, sirs, for your responses. And thank you, audience, for showing interest in each of the topics that was taken up at this national webinar. To meet, to depart is the way of life. To depart, to meet is the hope of life. With these parting words, may I now call upon Mr. Manoj Hebe, the College Sports Director and Program Coordinator, to propose the vote of thanks.
Good afternoon all. It is my privilege to propose the vote of thanks on the occasion of the national webinar on sports law. On behalf of Kare College of Law and also on behalf of its Alumni Association, I express our gratitude to our ex-faculty member, Dr. Sairam Bhatt, who has throughout guided me in the organizing of this event. Sir, we thank you for your valuable inputs. I thank our resource persons, Dr. Lovely Das Gupta, Dr. Vivek Anand Sagar, Advocate Rohit Kamath, and Professor Dr. Amresh Kumar for spending their valuable time and sharing with us their knowledge on the various topics. Your presentation were a reflection of your expertise in the field of sports law, and we have benefited by your learned thoughts. My gratitude to respected President of our Board of Management of the Vidyavikas Mandal and Chairman of Governing Council, Sir Nitin Kukalekar, First Vice President, Advocate Pritam Morais, and all my esteemed other board members. The Board of Management, led by its dynamic President, has always encouraged and supported the staff to attain higher heights. We remain indebted to you, sir. My special thanks to Advocate Prasad Naik, President of the Alumni Association of our college, and Alumni Committee for being part of this webinar. I take this opportunity to thank Dr. Maria Goretti Simois, IQAC Coordinator, Dr. Shruti Nadkarni, Professor Sonali Naik, Professor Sriharsha Inavali, and Professor Afshan Khan for helping me in this organization. I also express my gratitude to the entire technical team of Vidyavikas Mandal, Mr. Rupesh, Mr. Azan, and Mr. Punaru, and also some of the press reporters who were part of this webinar. My vote of thanks will be incomplete without expressing my gratitude to my principal, Dr. Saba Da Silva, who has been instrumental in the planning and organization of this webinar. Last but not least, I thank all the participants who have supported us by their valuable presence. Thank you all. Thank you.
I would request the web administrator to request all the participants to open their video to have a screenshot of this webinar. That will be far better memory for webinar.
Yes, sir. Certainly, we would oblige you. Before we part ways and before we log off and before we take a screenshot, a reminder, please kindly fill your feedback forms. It is only upon which you will receive your certificate of participation. Please fill the feedback forms. We could enable our cameras so that we could take the picture. Dr. Saba? Dr. Saba? Saba sir, please enable your camera.
He's on the screen. So he's not on the screen. There are 15 other people, those who have not enabled their camera.
Smile, please. Thank you. Thank you, everyone.
Thank you very much.
Okay, one more since many students have joined in.
Okay.
Thank you, everybody. It's been a wonderful experience. And
Thank you so
we leave enriched, and I wish good health and long life to everyone. Thank you.
Thank you. Thank you so much. Thank you. Bye.
Bye-bye.
Thanks.
Thank you so much. Thanks a lot for having such a wonderful session.